history here. I'd like to get this hearing in today. You know, everybody needs to just focus on the relevant facts, okay? I know there's a history here.
Are you talking up by Sunset Mart? Up the hill by the gas station?
Yeah.
Okay. Why did you... All right, who's responsible here? Who's responsible here? Whose house is this? Yeah, haven't been drinking or anything, right?
No.
Okay, drive careful, okay?
Thank you.
Good morning. Let's get it in. Fired up.
The other group that ran away.
Well rested.
Oh, really? You just ditched it? Awesome.
Yeah, those ones kept walking in the car. And the other one.
It's truly for the win.
Woo! Go Buckeyes. Grab the coffee. Grab the Jameson. Where's my Ireland folks? Let's do this.
That I was given to. So there was 2 different discs. Okay? They all knew about it.
Okay.
Okay, yeah.
But this is the second noise complaint we've had here tonight within 2 hours.
How are you?
Good, how are you?
Good. Is this your place?
Yeah.
Perfect. You know why we're here?
I see noise.
Noise, yeah.
Yeah.
Big speaker right there.
Yeah.
Nothing against having a party. Once neighbors start calling in, then we have an issue.
Like brains, and like if you need a lot of brains, you're gonna be in trouble.
Oh. What's up, guys? Good morning. Good morning. This was a surprise marathon, but I think you guys are gonna dig it. Again, hello to everybody. Hello, 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 hello. I mean, who goes live at 9 a.m.? I bet you everybody on UK time is loving this. It's probably like, what, 2? Maybe 3? Oh, if it's your first live, way to subscribe. Way to subscribe. Hector, the projector, is going to get some work right now. This is just a marathon, guys. It's going to be all over the place. But we're going to start with the grand jury because it's kind of like the end. And then we're going to go back to the beginning. And it's only because of the 24 raised questions. So let's take a look. See, what's up? Listen from bed. Listen from bed. That's what I would do. I have to give a shout out. You know, people think I'm wild. People think I'm crazy. Turtle Boy, I don't hold the candle to his flex on First Amendment speech, man. He was cracking me up last night. I was listening to Turtle Boy and him talking about Liz Proctor and that, hey, your husband, yeah, he's going to jail. Your kids, they're going to grow up without a dad. I'll be their daddy, though. I was dying. I was like, oh, God. He's like, you know what? I feel bad for those kids. But you, I don't feel bad at all for you. And I'm over here just like, oh, shit. He was twisting a little bit last night, but shout out to him. First Amendment rights. I mean, but yeah. He said, your husband going to jail. It's like, damn. We were talking about Jennifer Coffindaffer too. Because she's Turtle Boy's covering the Karen Reed case, and here comes Coffindaffer jumping on the bandwagon of law enforcement is so good, they don't ever do anything wrong. Well, I bet you a lot of people in prison would wish that was the case. But she's wild. Jennifer, man. Come on, man. A fellow female. You're going to take a better, closer look. And now we got them changing like the reports. Welcome there, Heather. So anyways. So he was over there. She should be in jail for propaganda. I should play a little clip of him going at it. He's like calling them twats and cunts, and I'm just like, whoa, yeah, wow. People think I'm like, Jesus, I'm shy and bashful compared to Turtle Boy. When Lana once shouted, "Way to go, God." Yeah. So if you haven't seen that episode that he just did last night, he had me rolling. He's like, Julie Nagel, fucking hate you. Now your brother, like you. He's just going down the list. But then we got to Coffindaffer and her Twitter account. But I do think that some of the stuff that I question, how the hell were you in the FBI? Because I believe if Jennifer Coffindaffer can be in the FBI, fuck any. I should have been already there. Not saying that I want to be there, but love how he goes and protests in front of the pizza shop. He's like going on and on about the pizza shop last night too. About listen, there's not some big drug conspiracy here, okay? These guys aren't the Mexican cartel. And then he says, they fucking sell pizza in Canton. I was rolling. But hey, if you don't know about him, just type in Turtle Boy Live and just go check it out. But here we go. Take a look. They fucking sell pizza in Canton. Canton's small. I'll be down over there in Canton. There we go. Love how he goes and protests. I do. I do know that we have a similar dial-up when we just take our phones out. Let's make some phone calls. I should call Turtle Boy right now. Is the bingo tomorrow? Oh my God, everybody's on this bingo kick. They told Bella she better be ready to bring it. I was like, everyone is out about this bingo. Yes. Bingo. Bingo is tomorrow. This is a good one. Salty Grace says, hi everyone, so excited. Was adding Halo lights, the Jeep, and TNT came over my speakers. I bet you got woke up, man. Be loud. Big Mike, what's up, Big Mike? With some double E's. All right, let's take a look. Going back to this whole grand jury. So this is my grand jury folder here. And I wanted to pull out the long list that they had of all the things that they were looking for. So a grand jury Whoop, see, that got pushed down a little bit. There you go. What the hell's going on around here? Come on, Hector. Here we go. But like, look at all this stuff that they wanted. Okay. That we're about to go through. All right. And so somewhere in this mess, somewhere in this mess of the world, do you believe that the 24 raises are just straight up out of here, or is there anything more? I believe that it did all come from the grand jury, but it's because of what was presented to them. Like, yeah, no, you used inadmissible evidence, sucky thing about not paying attention, missing out on bingo lingo. Turtle Boy is a knucklehead. I'm in Boston, and the fake news about Karen is crazy. What do you mean when you say fake news? So are you saying that Karen Reed's guilty or innocent? I'm just curious. Saw that pop up. Let's zoom in here. Make sure you guys throw some Jameson in your Baileys and coffee this morning. All right. So basically, they want all the transcripts. All right. They just want transcripts galore. But here, they want to know who was in that mofo. Who was there? That was interesting for me. Who was there? You want to be able to know who's hearing all this shit. So I don't think there's gonna be too many issues on page 1 for me. Page 2. What sticks out to you guys? I see normal. You guys, I get the cutest little things from Amazon. I got these electronic wipes, okay? Now, why would I buy these? Because I'm just so tech savvy, not. But I bought them because I figured out that they do a phenomenal job on my transparency paper. Just like fucking look at this shit. Boom, gone. I have a ton of transparency papers, but when I was doing a little case study on my own, the hector. So the electronic wipes work perfect for Hecky. He hates when I call him Hecky. You guys, I used my Hector the projector in court for the first time. And because this fucking thing's badass. Let me tell you what I can do. I can record everything that I'm doing right now with the projection screen. I can press record. See where it says like play, record, like all these fucking crazy ass tools. I can then also take pictures of every single thing and I could batch them out. Check this out. So I can go to like here where it says scan mode, and everything that I put underneath here in a clip, it goes into a PDF, and I can just bump out exhibits in order for when I would go to court. And I'm telling you right now, paralegals, lawyers, you guys need to give me a call and let me tell you how to get hooked up with Hector. You guys can't name him Hector, but that's just me. But for teachers, anybody of you guys that do like online shit, come talk to me. Let me help you make your life so much easier. But time, why work harder when you can work smarter? So if you, I mean, you could even be in like the business field, and you got to put proposals together, and you got to put business plans. Let me help you. Let me help you. So hit me up. But your electronic wipes look perfect for your projection screen, your transparency paper, which goes perfect with transparency, truth and transparency. So I went ahead and I asked Ann Taylor if I could interview her for my documentary, if I got first dibs. I said, "Dear Ann, there has not been a motherfucker out here that has gone harder for your purpose. Not to free Brian Kohlberger, but your purpose as in a public defender and your job. And if anyone is going to give you your story to be truth and transparent, love, Lana." No, I'm just kidding. I didn't rate her. I sure as shit wouldn't say that shit. I'd say, "You a dumbass if you don't come over here." All right. You guys, we're in for a marathon. So this is going to be probably amazing for all of you guys who don't know how I operate life. Do a live on how to use Hector, Susan says. Susan Gardner. All right, take a look, guys. What do we see? Anything that sticks out there that you are like, oh shit, right here. What sticks out to you? Oh, by the way, I have my weekly report available for how much screen time I use. So my weekly report, it says your average last week was 12 hours and 30 minutes of screen time per day last week. So if y'all don't think I've been working overtime, 12 hours and 30 minutes of use on my iPhone. That's because I use all my devices like crazy. All right. So what sticks out? You guys are like, I ain't even looking at that. I'm laying in bed listening to your dumb ass. Whoa. Okay, K sticks out to me. Fuck black. Hate black. We'll go with blue. Actually, we should go with red. What color you guys want? Blue? The pen is royal blue. Okay. K sticks out to me. Like, where do you think that they found? Oh, red. I think that the charge of the jury, the charge to the jury. Yeah, we're gonna have problems there. Any opening statement or jury instructions? We know there's problems there. Any indictment prepared by the prosecutor for consideration. Or at the request. We might have some issues there. All recorded proceedings in this case. Again, this is everything that they're asking for in that motion. Any subpoena and subpoena. A list of the vote, any return indictment, any evidence right here. Wait till you see my favorite part, though. It's on the last page. Any evidence for the defendant requested ordered to be produced by the grand jury. So, like, what did you know? Oh, you guys can't see that. M. Foster says, F, the charge. You think there's going to be issues in the charge? Interesting. HK, H, any evidence presented to the grand jury? Yep. That's the big one. Okay, because that's where you're going to get your inadmissibility. Okay. Now, let's see. And here we go. A copy of any and all orders, a transcript of the initial seating of the grand jury. Deja vu, remember, for 5 months, baby. Come on, baby, kick them daisies. Look at them girls in the Daisy Dukes. All right. What's the names of the grand jurors who heard the evidence against the defendant? Now, was the grand jury then gagged? You know, the instructions like, you can't talk about this with anybody? Because there was... So do you think that some of this could also be if they're trying to find out who's leaking stuff, if there is a leak? Right there. Okay, check this out. Here we go. Now, what was the order that came from this? Remember when they did their hearing, they said there were an impasse on some stuff because they had stipulations that they didn't agree to. And so here it comes that now we get to, this is the order, what was given. And select portions of the grand jury record and transcript may also be shared with any witnesses who testified at the grand jury proceedings. But for each witness, only that portion of the redacted version of the transcript that contains his or her own testimony. Okay, So that means that you get like, let's just hypothetically say that Dylan testified. We have, here's her time that she was up on the stand. This is what she said. Here we go. We got it. Okay. We see what she says. Then I can then take this to Dylan, show her this, and say, this is what you testified to the grand jury. Do you remember this? But I can't show her what Bethany testified to. If Bethany was to testify. Again. Also, what you're going to do with all of like the testimony, right? You're going to then compare it to all of the notes, all of the reports of all of these officers. Okay. When you testify in your grand jury that Blaker, you said you saw the sheet, but nowhere in any of your reports or your body cam did you see it when you first were there. But in your grand jury testimony, something like that. So you're going to want to take those notes. You're going to take the notes that they have, and then you're going to compare it to the grand jury testimony what they said. For example, this is one of my binders from the Davon Cox trial. Okay. And opening instructions. Okay. Again, this is voir dire. What's up, Nancy? How are you? So I want to go sample some of this, but as the judge told you, the opening statement is my chance to lay out our case against Mr. Cox. It's often described as an outline or a table of contents about what the evidence we are going to present we believe is going to prove. It's not my chance to argue about what the evidence means. Nancy, are you gifted memberships? I can't ever see it on this side. Aw, Nancy. That will come after all the evidence is over with and the trial is done. Now, actually, hold on 1 second. Holy shit. Kelly Miller. Cash App. $200. What, girl? Kelly, are you here? Thank you so much. Kelly, thank you. Thank you, Nancy. Thank you, members. What is this Lana blessing you woke up to? Sure is. Oh my God. Thank you. Thank you. Thank you. More gifting. Thank you. Thank you. Oh my God. Thank you, Kelly. Hot damn. Love the picture too. Thank you. That was very, very kind. Actually, this is the opening statement for the trial. Hold on. Okay. Now, I like to compare stuff to past cases. So I could show you guys. This is a case out of Pennsylvania. So we're dealing with the same type of cops. So let's take a look. That's so many things here. All right. Oh, shit. That was not good. All right. So here is the index for like when you get your transcripts back. All right, this is you can print them off on like 4 to a page, and you go through, and you're gonna get this is just your transcripts. Like you'd read this, and you go through, and at the end of it, there's an index. So basically, any word that was said, you can go back and look at the word, and you can find out where you're going to find it, what pages. So, for example, the word, aliquippa, it can be found in all those pages. Okay. Just trying to think of more like the word car. Okay, it's found in all those pages. Right. So when they would have gotten these transcripts from the grand jury, obviously they read through them, but there's plenty of different ways to go about that. And in this case, with the Davon Cox case that I have here, there was actually 4 defendants. Okay, 4 defendants. And first of all, he got the worst fucking, I could have represented him better, and I'm not a good lawyer. I am I've never said I was a lawyer, by the way. I am one hell of an investigator. That's what I am. I think I'm pretty organized. But something that I went back and grabbed this case for was because all of the defendants were dressed in suits and ties, except for one of the defendants. And I want you guys to take a look. So I'm going to zoom in. And this is where each of the attorneys are stepping forward and they're saying, okay, who is representing Enrico Jackson? Okay, that person, Mr. Hicks, that person, Stevenson. Mr. Rivas, Your Honor, I represent Mr. Rivas and Chad Bowers. Thank you. Mr. Walker, okay. Is there also a Mr. Cox also? Yes, there is, Your Honor. Okay. Okay, so good afternoon. So you see that you have all these different attorneys for these 4 defendants. Now, check this out. Right here. The court, or I'm sorry, this is the prosecutor. Your Honor, we have voluntarily sequestered our witnesses. The only people in the courtroom are here to assist the prosecution would be the prosecuting officer, Sergeant Couch, and the lead detective in the case, Kim Clemens. Nobody objected to that. Nobody objected to that. Okay. Now, this isn't a grand jury proceeding. This was at the preliminary hearing. This is preliminary hearing. Right there, though, if you know anything about this case, as these lawyers did, I would object to Couch and Kim being there. Why? Because they're testifying. And why should they be able to hear the testimony of everybody else that's testifying? That's not needed. So I was shocked to see that was not objected to. Now, right here, they're taking care of a preliminary matter when they want to say that, Your Honor, I would ask my client who has handcuffs on, have the handcuffs removed so he could assist in his defense by taking notes. For the record, motion is denied. What motion? The motion to have his handcuffs removed? This is a preliminary hearing, for the record. Now, then the state says, okay, we're going to call Brandon Morgan to the stand. Okay. Now, you don't have to know anything about this case. I just want you to see what happens. So you're going to take, this is the preliminary hearing. And what you're going to be able to do then is anything that they say in the preliminary hearing, you know, you can then, when they go to testify at the actual trial, if it's different, you know, you have this to impeach your witness. Now, okay. Now check this out. First of all, could you take a look around the courtroom and tell me if you can identify that individual? Is he positively here? Because they're asking questions about, I was a manager at a Finish Line. They were asking about his girlfriend, the neighbor, and then they said, during the course of your employment at Finish Line, did you have a chance to meet an individual that identified himself as Marquay? Okay. Right here. He said, yes, I have. And first of all, if you could take a look around the courtroom and tell me if you can identify that individual if he's here. this guy Brandon says, I can't see too well. You can stand up. Take a look. Second gentleman in the green. Seen that face before. As to if it was the one in finish line, I'm not positive. Question. If you're not positive, don't guess. And then the defense attorney steps up and says, the answer was the second one. Witness, I recognize that face. The second one. Then the judge said, he said in the green. Okay, I'm sorry. I didn't hear. Now, these are little notes that were taken. He IDs the wrong guy. He IDs the wrong guy. Yet, when he was given a six pack, okay, what they do is they hand you with instructions on what to do. And the victim in this case couldn't identify. That's why there's no mark in what you think who the person is. Okay, so this is how this works. And this is actual fucking discovery. Now, when Brandon went and was sitting there at the police station to do his identification, he identified the person within 10 seconds. But here today at this preliminary hearing, he picks out the wrong guy. Okay? He points to the wrong kid that he's labeling Mark White, just so you can hear how this is going. This is all right. Now picture this being the grand jury. The next part here. When he says, how did you meet this individual? Employee of mine named Rashad Brown from Finish Line introduced me to this person. Okay. Can you believe that Rashad Brown was never brought in to testify, was never asked by the state to testify, then was also never asked by any of these defense attorneys to call him this Rashad Brown guy. I reached out to Rashad Brown. Because don't you think it would be really important to be like, okay, well, if Brandon is saying that, well, I know the guy and I met him through this Rashad Brown kid, then don't you think Rashad Brown is probably a material witness? Why wouldn't one go and talk to this Rashad Brown, right? Now, think about it now in terms of the case in Idaho4. Who did you call to the with part of the grand jury as far as testifying, and who didn't you? So to me, sometimes it's not about who you called, but let's take a look at who they didn't call and why they didn't call. That's how I would look at it from an investigator's situation standpoint. If you handed me all this shit, because immediately I picked out, I said, well, what was this motherfucker ever questioned? He'd be super material to, especially once you're on the record, your homeboy who you need to identify, like these motherfuckers, he just says that I can't positively identify. Well, you better then go to Rashad Brown so that he can say this is who the person was that I introduced him to at Finish Line. You know what I mean? Well, I reach out to Rashad Brown. Say, Rashad Brown, hey, what's up? I'm doing a documentary. What's your take on Black men being targeted and being set up for something that they didn't do? What's your take on that? I said, do you remember an incident back in 2004? Because can you believe it that the lead detective of this case made a phone call to Rashad Brown the night of this incident within just less than 1 hour of being contacted that there was an incident? This lead detective from Beaver County wouldn't know dick about dick at that point to even you don't have anything. Why the hell would you call a Rashad Brown? Rashad Brown. Why? I think I know why you call Rashad Brown. Anyways, but you need the material. And so looking at all this type of this questioning, seeing who was really called, seeing who wasn't, but you're going to be able to take anything and everything that a witness said here at the preliminary hearing and use it then to remind them of what they said once the trial comes. And what this situation was this was a drug deal that the people that actually set up the drug deal were then going to rob the people that they said they were going to steal the drugs from. And they caught on, and then instead of these people saying that there was a drug deal and to get out of it, they blamed the Black kids for raping a white woman. And Davon's still sitting in prison for this, which I'm trying my hardest to help him. But not too many people want to listen to when I do my investigations on African Americans that have been wrongfully, accused and convicted. But the point of this is that looking back at this case, if anybody did a damn of which clearly Ann Taylor is, you're going to be able to take everything that was used with the grand jury testimony. Davon didn't have a grand jury. He had a preliminary hearing, which is what Brian should have had. And that's what this is from. This is from a preliminary hearing. But in the middle of this preliminary hearing, at the end of, and almost to the end of this Brandon's, this is their star witness. They start objecting here at the end. And since there's 4 different defendants, each defense attorney gets to cross-examine this man, okay? And right here. Check this out. Now, this is on cross-examination. Question. From the time that you went to the convenience store to the time that you went to the New Brighton apartments to go get these drugs, allegedly, and to the time that you went to the ATM machine, how much time do you think elapsed in that period? Can you give me any ideas? What he asked this Brandon kid. And he said, we picked him up around, like I said, 10:15. From there, it was probably past midnight. Question was, half an hour past midnight, little past midnight, probably a little past midnight. Then this defense attorney goes and grabs, so he's basically saying that we were probably at that ATM by no later than 12:15 in the morning. Then he goes and he grabs this printout. He hands it to him and he says, would you be surprised if the photograph on the ATM machine captured the timestamp at 1:48 a.m.? Would that surprise you? He said it didn't seem like that much time had passed, because this is all a story, you know. And it shows him the photograph. But right here, when you know you're doing something right, immediately the prosecutor says, I object. He doesn't have any knowledge about that. Excuse me? He doesn't have any knowledge about what time he went to. I'm going to withdraw that question, Your Honor. Question. You wouldn't have any reason to doubt the time being 1:48 a.m. when these photographs were taken, would you? Would you have any reason to doubt that? He rephrases his question. That I would not, because we were picked up after 2 o'clock by the police officer. How much time elapsed from the point when you took the money out of the Mac machine until the time that you were forced out of your vehicle and flagged down the police officer? That I don't know, because I blacked out. This is all a story that they're telling. They're lying about how this whole thing went down. Okay. And this defense attorney is doing a phenomenal job of catching this kid in this elaborate lie, but not that he made up. He was given this from the police to say, okay, because they wanted these kids. So we're going to let you go on that what you were trying to do to them, but this is what you all are going to say. That I do not know, because I blacked out. Question. When you say you blacked out, so think about Dylan. You guys think about Dylan. Okay? This is really, really important. Dylan takes the stand. She's going to talk about this. Was it at 3? Was it at 4? What you do this time? Why do you think it was this time? Why do you think it was that time? Okay? So think about how valuable the preliminary hearing would have been for Bryan Kohberger, or anybody that would be in the position of being a defendant. You want your preliminary hearing. Okay. Again, when you say you blacked out, did you collapse on the ground? I was sitting in the back seat. and my eyes began to feel very heavy, and I got lightheaded, and I don't remember seeing anything or hearing anything from that point. The reason why is because this guy was driving the vehicle. He passed police stations. He passed police officers. Okay. And they tried to ask this guy and said, well, why didn't you? Well, I had a gun pointed in my head. I had a gun pointed in my head. And then he said, and then the guy pistol whipped me, puts me in the back seat, and then he starts driving. Okay. And so the question was, then he says, maybe I make that bigger for you. Question. Maybe I misstated it. I'll ask the question again. Do you know how much time elapsed from the time that you were out of your vehicle and the vehicle drove away till you flagged down the police officer? He says that would have been around 20 to 25 minutes. During the time when you were taken to the Mac machine, did Marquay say anything to Antoine? He had told him that when we got to the machine, that he was going to make him get out with me. So Marquay was going to make Antoine get out? Yes. Oh, wait, I'm sorry. Did I skip over that? Oh, yeah, I'm sorry, right here. Oopsies. Yeah, right there. Did Antoine tell Marquay, I don't want to do that, anything like that? No. Did he say anything? No. He just kept silent? Yep. And this was after Marquay had already put the gun to your head, put the gun to your girlfriend's head, and shot out the window of your vehicle, isn't it? Yes, it was. Those are all the questions I have. Now, right here, they had him by the nuts. He totally fucked up this time. And I said to myself, what is he doing? Why did this defense attorney, and then I realized, because it's a preliminary hearing. It's a preliminary hearing. And that means it's going to fall on the judge. This isn't, I have to prove this to the jury, you know. I got to get this across to the judge that this motherfucking kid is a lying, and I don't need to keep going at it. As a judge, you should see what we're basically saying here, okay? But had this been a jury, this line of questioning wouldn't stop there with that. Now now take a look at this. You have these other defense attorneys that are being asked, okay, would you like to have your shot at him? Mr. Cauliflower, yes, Your Honor, I don't have any questions of this witness. Then Mr. Townsend, I don't have any questions at this time. No, Your Honor. And then now the state. I just have a few redirect. Question. Sir, so you testified, we could agree, at first you picked out the guy in green as Marquay. Then you picked out the guy in the green as Antoine. Now, today you told Mr. Bowers that you're not sure which one he is. Is that correct? Correct. Correct. He identified this guy as being two different people and then says, I don't know. State says, was there a time when you were requested to do a photo lineup? Yes. And pick him out? I'm going to object. Your Honor, the same objection. And I think that Mr. Palladina is mischaracterizing when he says, I'm not. You weren't sure which one was when he is talking about Mr. Bowers' question. He's rephrasing the way the question was worded. Mr. Bowers' question, it's still the same. He identified one individual. He goes to the Commonwealth again because it didn't get the answer that it wanted, Your Honor, and trying to rehabilitate its own witness with regards to someone even other than the fellow in the green over there, I object. I thought you ruled on this, Your Honor. And the Commonwealth, just because they call it redirect, doesn't give them a chance to do what they couldn't do up to this point. Your Honor, I'm permitted to bring up a prior identification that happened closer to the time of this incident, where his memory was, and then, Your Honor, that's what you ruled. It's a prior inconsistent statement. Now think about this in terms of the Idaho4 case. Picture Bethany on the stand. Picture Dylan on the stand and how they're going to be asked questions. But now think about the grand jury. And you're just fed one fucking version, man. Now watch this. The court says, I understand. The Commonwealth is trying, I will sustain your objection. Thank you, Your Honor. I don't have any other questions for him today, subject. I may have to recall him if we have to. Your Honor, at this time, may we approach the bench? Now, look at this right here. This is Mr. Bowers. Mr. Bowers. Look at this. Mr. Bowers was the same guy, okay, that had the opportunity to go the fuck at this person, okay? And he went, had him by the nuts, and then totally fucked this up right here. Then nobody else asks questions, but right here, Mr. Bowers wants to jump in and say, Your Honor, at this time, may we approach the bench? This is Cox's attorney, Mr. Sheen. On the record, Your Honor, may we approach the bench on the record? So Mr. Bowers, one of the other defense attorneys, says he wants to approach the bench. Mr. Shaheen, he steps up real quick and says, oh, yeah, on the record, though. On the record, Your Honor, may we approach the bench? The court says, on the record. Sidebar discussions on the record. Listen to why. Mr. Bowers says, Your Honor, at this time, I'm requesting continuance for Mr. Rivas for the following reasons. I believe there will be additional witnesses who will be called. Mr. Rivas is sitting here in green. The other defendants are sitting here in orange jumpsuits. For that reason, I would request a continuance to another time when they can all be dressed the same way. I believe he sticks out as a sore thumb, Your Honor. The Commonwealth says, I have no objection. The court says, any comments? Now, Mr. Caulfield is one of the other. He's like, on behalf of Mr. Walker, co-counsel, I certainly don't oppose a request for a continuance. If you allow a continuance, I don't want that time to go against my client. I'm not requesting a continuance on his behalf. So the court knows if we want to treat it as a court postponement for the time, reasons, or whatever, I'm fine with that. The court says, you're going to be on the record. Mr. Shaheen says, I'm not going to object. Co-counsel makes a good point. I won't object. And I'll go long, although I take Mr. Caulfield's position also, because I also would not object for the reason I would like to, my client is on a $35,000 straight cash bail with pretrial services. I would, for the record, ask the court at least consider reducing that. Although there has been a bond hearing. I don't know what the procedure is correct anymore. I think with our case, it was a good bond hearing, so I will withdraw that. Then this guy says, I'd like the record clear. I'm not asking for a continuance. And since I have a client who is in custody, I don't want this case continued for long. As of right now, there is nothing to tie my client. I don't know why he's here. Right here. Now, I have a question for you guys. The hell is going on? Why in the world would you not have that objection? Because then they tell Mr. Morgan, hey, you can't, talk about this with anybody. Okay. Why wouldn't you have that objection when you saw your client dressed the way the other people were dressed? Ooh, don't know. Anyways, if anybody wants to know what I'm talking about how other cases you can use to see how things would be handled. And I use the Davon Cox situation to show that Davon Cox had a preliminary hearing, so that's why I have all this material, as well as all the transcripts, 2,600 pages of his actual trial, and all of these reports. And without this preliminary hearing, there's not this awesome impeachment of all the people that testified. So what you're looking at, though, think about this. In the case of the Idaho4, Bethany, Dylan, police officers, anything that they would have said in any of these reports, which clearly something's wrong because the defense attorney found it. Had you had a preliminary hearing, a lot would have happened, but you didn't. So you don't have that material to impeach under sworn statements. But you still have the police reports. And so we go back to the grand jury, and it's like, what the fuck did you give to the grand jury? 24 issues. So, in this case, was a very good example of the amount of time that had lapsed. And when someone said they passed out, and that's why they don't remember things correctly. And I was just like, wow. So with that said, now take a look. If you think that Brian Kohlberger was set up and framed, how would I ever trust anybody to not ever give the transcripts to, like, well, here, I'm going to let you see what this person said because you need to have the same story. We're supposed to just take the word that I didn't give the trial transcripts. I didn't copy it. I didn't have someone come in. I didn't go to their house and say, hey, take a look at this. Look at what they said. How can we fix this? Remember when we talked about, they brought up that it was a prosecutorial misconduct? Okay. Do you think there's at all anything that could possibly come? Does everybody understand what state was Mr. Cox's case in? Pennsylvania. Yeah, I can prove his whole case. If you go to Sunset Secrets, there's the Davon case. I talked to Davon here. Actually, you guys want to talk to him? I'll tell him to call me from prison. Let me head up Lindsay. You guys want to ask Davon some questions? Yeah, they were just passing out gifts. Okay, so my question is what do you guys think? 50 gifted memberships. Thank you. Holy Mother Mary. Yay, he hasn't called me back yet. He's call soon. Okay, perfect. Yay. Call me when he does. Okay, good. So Davon should be calling here a little bit. So was Davon's like a drug deal turned robbery turned alleged rape, and everybody else took deals and stuff like that, and he didn't do what they were accusing him of doing. So he was like, I'm not taking a deal. I'm not going to let my kids think I raped a girl that I didn't rape. And so, but there's a backstory behind it too. Pennsylvania State Police was out for, and the Idaho4 police were out for his mom due to the Jamie Brown case. So he'll be calling around 11:30 to noon. I said that's fine because we're on a marathon here. So actually, Hi, Miss Lindsay. You're on speakerphone.
How are you?
Good. How are you?
I'm good.
I was just talking a little bit about Davon, and I was like, you know what? I want to bring him out when he calls, because we were talking about preliminary hearings versus then the actual hearing, and just how shady it was for him. And wanted to hear from him, have him on the show for a little bit, and then I can just talk to you guys off of camera or whatever. But how are you? Happy Labor Day weekend.
Thank you.
So are you doing anything?
No, I actually have to be at work at 2, so.
Okay. Well, you said you think he'll call around like 11:30 or 12?
Yeah, because I just looked at the time, and they go in and come back out and all of that. So I don't think he'll call back until around.
Mm-hmm. All right, well, perfect. Then are you cool with hanging out on the phone with me for a little bit with Davon?
Yeah, that's cool.
Is that cool?
Mm-hmm.
All right, cool. Well, then just call me back. I have my phone on ring, and like I said, I'm live. So when you call me, I'm just going to answer it, and I'm excited to hear from him.
All right.
Okay, baby, I'll talk to you then.
All right. Thanks, Anna.
Okay, yeah, you're welcome. Bye, girl.
Bye.
Last night so I want you guys can have it from an insider perspective of things and what he saw go down in the preliminary hearing, because you're gonna it's mind blowing. Anyways, you guys are here for a marathon. So what that means is we're going to talk about this whole case, top to bottom, whatever truth and transparency is talked about. But I wanted to start with the grand jury, and then we're going to go back to the beginning. And the grand jury is, in my opinion, we got 24 issues. And the prosecutorial misconduct, to me, like, I'll tell you guys about an experience with me, and you guys can tell me what you think. So the state, the prosecutors, as well as defense attorneys, as well as anybody that goes and gets a license, passes the bar to become a lawyer, they have a professional codes, okay, that you have to adhere to, okay? Misconduct, right? There's things, and so what I'll do is I'll show you guys, let's just use Ohio for an example, okay? There's certain things that you can and you cannot do, all right? And one of those things would be you cannot lie or mislead the tribunal, okay? You cannot lie or mislead opposing counsel, okay? But here, I don't want to have to show it to you. Let's just take a look. Let's just do what we do, boo. Take a look. Let them out. Share screen. Yeah, it's a huge deal. So let's take a look here. Again, thank you so much for anybody that has gifted a membership. Also, hang on. I got a little notice here. What does it say? It says, last night. Allison, thank you so much. $5 super chat through the Cash app. Boom. Damn. Feeling the love today. Let's see. All right. There you go. Look at that. Ohio rules of professional conduct. Right? So, for example, let's go with declining or terminating representation. For example, a lawyer shall not represent a client where representation has commenced, shall withdraw from the representation. Again, and these are your, your codes, your ethics, your professional. Let's see. You cannot continue to represent somebody, okay, if the client persists in a course of action involving the lawyer's services that the lawyer reasonably believes is illegal or fraudulent. The client has used the lawyer's services to perpetuate a crime or fraud. You guys know that filling out false police reports is a crime, right? You guys know that perjury is a crime, right? Okay. So if you have a reasonable knowing, damn, this bee just totally fucking lied to me. You have a duty to what? Drop the hoe or the dick, who you're representing, you know? Again, just giving you guys some examples here. Now let's take a look back over here. Now, let's see. Communication. Let's talk about communication. A lawyer shall do all of the following. So, like, Ann Taylor has to reasonably consult with the client about the means by which the client's objectives are to be accomplished. Now, Tiffany, thank you, Tiff. $5 cash app. Woo woo. Diligence. Your due diligence. Last night we lived. What's the page I wanted? Let's go back to this. Okay. Transactions with persons other than clients. Truthfulness in statements to others. Communication with person represented by counsel. Dealing respect for rights of third person right here. Truthfulness in statements to others. In the course of representing a client, a lawyer shall not knowingly do either of the following: make a false statement of material fact or law to a third person. For example, if you knowingly know something to not be true, let me zoom in. What the hell am I thinking? You guys can't see that shit. There you go. For example, if you know that something is not true, you cannot say it. Make false statements of material fact or law to a third person. This isn't just in Ohio, by the way. Fail to disclose a material fact when disclosure is necessary to avoid assisting an illegal or fraudulent act by a client. A lawyer is required to be truthful when dealing with others on a client's behalf. A misrepresentation can occur if the lawyer incorporates or affirms a statement of another person that the lawyer knows is false. Misrepresentations can also occur by partially true but misleading statements or omissions that are the equivalent of affirmative false statements. For dishonest conduct that does not amount to a false statement, or for misrepresentations by a lawyer other than in the course of representing the client. Now, statement of fact. The rule refers to statements of fact. Whether a particular statement should be regarded as one of fact can depend on the circumstances. The client can, of course, prevent such disclosure by refraining from the wrongful conduct. If the client persists, the lawyer usually can avoid assisting the client's illegal or fraudulent act by withdrawing from the representation. Now, for example, and I'm going to use myself. As the example. When I did my court cases against Vanessa Walsh, she had an attorney. In Colorado, not when she went to file the ex parte, but then at the hearing, she obtained an attorney. Then it was continued, went back out there, attorney. Then everything that has happened in Ohio, attorney. Until this last Thursday, when my 14th Amendment rights were violated for due process. I have the right to due process. I have the right to be heard. But more importantly, I have the right not to be lied to. And so I'm only going to use my situation to show you where Ann Taylor's frustrations probably lie, to the point of this is not frustration. This is misconduct. This is prosecutorial misconduct. Okay. And let's see. Now, let's see how I want to show you this. Again, hello, everybody. This is just a wild, wild marathon. Again, we're talking about everything Idaho4, but the best way that I can relate it is to show you guys examples. Now, okay. If your husband or wife hits you and beats you, and you get a black eye, you don't take any pictures, and you go to, you know what, I need to get a fucking restraining order. And you go there, and it was, a month has passed, the black eye's gone, I didn't take any pictures. And you give the statements that this happened. They can't prove it. There's not enough proof. Okay. So they don't issue a restraining order. Now, 6-7 months go by. Your ex-best friend contacts you and says, after you get beat up again, and your ex-best friend contacts you and says, Jesus Christ, again. I was there that night. I'm going to testify. You need to go get a restraining order. This is ridiculous. I have material information that is relevant to show a pattern. And you have, obviously, what the fuck just happened to you right now. But I'm your witness to show that this is a pattern. And then obviously I'm here for you on this time. And guess what? I never told you this, but I kind of slept with your man back when we were like hating each other. And again, this is all hypothetical. And when I was doing that, then I started doing some things that I'm really not proud of, and blah, 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 blah. Jesus Christ, you know. So I go to file a restraining order against my husband, my boyfriend, whatever. And I have the right to be heard. Due process, your 14th Amendment right. I have the right to be heard. I have the right to have witnesses and evidence heard. Now, I go ahead and I serve the son of a bitch. I don't hear anything back. So I got to take this motherfucker to court, you know? So I hit up the clerk and I said, hey, what do we got? Do we have service? Do we have proper service? Well, somebody signed, but it was not your husband. So the courts are not counting that as proper service. And so therefore your hearing that is, you know, in 2 weeks is not going to be happening because proper service. So you're going to have to wait till, you know, after that date that you had scheduled to have the hearing. You have to wait till, you know, after that date because it will get continued. And then you can give us maybe a new address, or we can go ahead and try to serve, you know, again. And I said, wait, what do you mean? What do you mean? Somebody other than my husband signed for papers. Who? I'm coming down there and I want to see what's going on. Who? What do you mean? I addressed the papers to him to sign, his work address, where he works, what he puts down as his address on his company. And so who signed? Who would sign for someone's certified mail if they're not the person? So when I was notified about, like, hey, somebody signed, but it's not the person, I went ahead and I reached out to the counsel of this person and said, hey, good afternoon. Did you sign for so-and-so's certified mail that contained the TRO hearing in Ohio dated for August 24th, 2023? This was sent to your office in order to comply with the no contact order. In addition, I am requesting a subpoena be issued for you to have your client produce material digital information, such as phone records and Facebook metadata downloads. Thanks. No response. A week goes by. Miss So-and-so, haven't heard back from you. Did you get my previous email? Looking forward to hearing from you. No response. So August 9th, August 14th, August 16th. Now, this is when I take my happy ass down to the courthouse and I was like, who in the world would sign for my husband's shit? I said, wait a second. I said, I'll be damned. I'll be damned. So I write another email. I love emails. Dear so-and-so, I am requesting a copy of the contempt citation motion that you filed with all exhibits from June 26, 2023. Next, I am making a third attempt to contact you via email on a professional level as it pertains to your client's upcoming August 24, 2023 court hearing that I filed with the Franklin County Courts on July 13, 2023. This is a professional attempt to contact you as I am a pro se litigant. I am requesting that you show me the same respect that you would any practicing licensed attorney. With that said, I hope you could advise me I hope you could advise me as why you believe proper service was not obtained by me mailing certified mail to your office as you have requested in the past that I do when attempting to contact so-and-so, your client, with these matters. I am actively trying to serve your client. And it seems to me that you are actively attempting to void my attempts to legally and properly serve your client as outlined by Ohio civil law. I am requesting your cooperation in this matter. Looking forward to your attention to this urgent situation and a professional reply. Same day. Dear Lana, I am not authorized to accept service of process in this case. I do not, at this time, represent so-and-so in this case. You did not reach out to me before sending any document to ask whether I would waive service, and I did not consent to the same. In order to waive service on behalf of a client in a new and different matter, I would need to get the client's permission to do so and enter into an agreement with her that I represent her in that case. If so-and-so does request that I represent her in this case, I will reach out to you. Well, now, it's so-and-so. Your email dated August 16th, 2023 was received. It seems as if you missed the first question where I addressed obtaining a copy of the motion that you filed on the behalf of your client dated June 26, 2023 in regards to case number where you were seeking criminal contempt upon my person
for an alleged violation of a PO. Can I please obtain a copy of that? Did that ruling come back yet? Next, I never received a copy of that motion. This would be the second motion that you filed for contempt with an affidavit of your person and so that included exhibits that you never sent to me as the pro se party. Is this normal practice by you and your firm? Just to be perfectly clear, so-and-so, after reviewing my files, Franklin County Courts sent the legal papers directly to your client at her work address for this legal matter. This was sent certified mail, as certified mail is deemed proper service in Ohio. These legal papers were dated and filed July 13th, 2023. You incorrectly implied within your last email dated August 16th, a week after my initial contact, that I contacted you to obtain a waiver of service. This is completely not true. I reached out to you yesterday for the purpose to obtain some professional cooperation, and prior to that, to ask you if you had signed for your client's papers, to which you never emailed me back August 9th, 2023. It should be noted that this is the first email dated August 16, 2023 from you where you have claimed that you do not represent this person in matters that pertain to this subject matter. Miss So-and-so, I never contacted you prior to Franklin County Courts serving this person with her legal papers through proper channels for any reasons as it pertains to this legal matter. So now, I have a question. Why did your assistant sign for your client's, your personal assistant paralegal, sign for your client's certified mail at your client's place of business on July 20th, 2023? All legal papers were sent and addressed to your client and sent to her work address that is documented with the state. To be clear, you chose to not disclose this information to me in your email dated August 16th, 2023, that being your assistant, paralegal, so-and-so, signed for your client's certified legal mail. Instead, in your email, you make no sense whatsoever and talk about irrelevant material to the facts of this legal matter. Your assistant signed for your client's mail at your client's place of employment on July 20th, 2023. See attached document. Are you implying through your email that you signed for papers on the behalf of your client without contacting your client for consent? Or did you sign for it knowing full well that you were her retained attorney for these matters that include my person and your client when it comes to these matters? Your staff had already signed for a document, and then you email me saying you can't waive service because you don't represent them? Question mark? Why would you be at so-and-so's workplace, or rather your assistant, and then instruct your assistant to sign for said papers if you in fact didn't represent this person, nor have her permission? Silly me. Let me correct this because I'm assuming you instruct your assistants with their daily tasks and duties. So let me rephrase my question. Did you instruct your client to interfere with my legal proper service to sabotage the service of my legal matter in Ohio a day after receiving notice from a magistrate in Colorado that she denied your second contempt citation motion to have me arrested? So after you realized it was a mistake to sign because, quote unquote, you don't represent her, you then thought it was in the best interest of this legal matter to make no good faith effort to attempt to contact myself or the courts to address said issue. Instead, you decided that when you received my email on August 9th, 2023, to ignore this email for over a week, knowing that on July 20th, your assistant signed for the papers. You then, when you finally responded due to my August 14th and 16th emails, you then attempted to mislead a pro se litigant, myself, with this legal matter. Please advise that you have received this email and that I can be expecting a courtesy copy of the motion with exhibits and affidavits that you filed in regards to your second citation for contempt. In closing, please acknowledge that you will speak to your assistant and immediately replace from your records, as requested previously by me in February of 2022, an address that you know does not belong to me with my actual address listed below. This will aid in preventing your firm from being able to attempt to further humiliate my person and interfere with my business relationships. This address was given on the behalf of your client to the courts in January of 2022 when she falsified legal papers to include this very same address in Pennsylvania as my residence, as a squatter, when in actuality your client had been well aware of my home address in Columbus, Ohio, hence the process server she hired immediately after she got her TRO. Respectfully submitted. Now, do you guys know what ex parte communication is? Ex parte communication is when you talk to the courts without anybody present besides yourself. Okay. And you guys know what so let's see here. So Miss Potts, wow, LOL. Don't want to get on your bad side. Truth. Bad side. Nobody gets anybody's bad side, you guys. So okay. The moral of this story is that I was 100%, according to the professional ethics codes, what you have to do as an attorney. I was without a doubt misled and flat out fucking lied to. Okay. To the point that you, as an officer of the courts, a lawyer is called an officer of the courts. How in the world let me just explain. when I got the paperwork that saw that the reason that this person's name wasn't assigned for, I said, well, it's because it's her attorney that signed for it. But the courts deemed it not to be, and I was told that it was not proper service. And so, but more importantly for me, what I was told from a officer of the courts was something that was not true. And in fact, it was conduct that would fall under misconduct, and that could be, if brought to the attention of the courts, would be like, holy shit. So I make it known. So how does Anne go about making it known that there's all this shit going on? Like, what the fuck are we supposed to do here? Like, look at all this shit. Like, we talk about a trial. We have so much misconduct going on that it's not just what happened at the crime. It's continuing to happen. So we need to how do we bring it to the court's attention of this is what's been going on? And it's still going on. Right? And what does Anne do when she looks at this and her team look at all this and they're like, holy shit, not only is that what happened, but it's continuing. So what do? We couldn't have an October 2nd hearing and a trial, and we had to waive our client's right to a speedy trial because of holy shit. So, using my example of life here, I go to the courts and I ask the courts, I supply all the communication, and I supply the information that basically I'm going to be taking action. This is an actionable, what's going on here is I have action. I can take action, and I'm going to. But I'm also allowed to bring it ex parte to the attention of the courts. And what they choose to do with that ex parte communication is, obviously it is what it is. Now that was August, 17th. Think about this. I then get an email on August 23rd saying that, I'm sorry, let me back up. I get an email August 23rd and says, hey, we were contacted by so-and-so, and they are going to be waiving service and appearing via Zoom with her attorney at 9 a.m. tomorrow morning, and be here on time because we have court at 9 o'clock in the morning on August 23rd. The fuck? Wait, excuse me? You already canceled and rescheduled this court hearing on August 9th. And I have all the documentation and so then in the morning on August 24th, I asked the courts for the same courtesy to appear via Zoom. That courtesy was denied. What? So there was no motion filed with the courts of waiving proper service. It's a motion that you have to file. That didn't happen. These are called procedural errors. Okay, procedural errors. Okay. So when I look at Brian Kohlberger's case and I think about Ann's case and what they're going to fucking talk about, all right, when you're talking about all the things in this motion, procedural errors. Okay. But not only were there procedural errors then, but now we have ex parte communication that granted the use of Zoom for one side and then denied it on my side. Wait a second. Right there alone, on the grounds of that you, within hours, are approving somebody's ex parte to appear via Zoom, and you approve the one, and then within hours you deny the other one. That is, so then you have another way that you can argue, object, and appeal, which is discretion. Did the courts, what their discretion? Was it bias? Was it prejudice? Now, it is your 14th Amendment right to be heard. That is due process. Okay. So, Ann Taylor's over here talking about, fuck, you just violated motherfucking due process, like this preliminary hearing. You know what I mean? Like, right to be heard, because that's like, but oh no, we went the grand jury route. Okay. But after 6 months of fucking all this crazy shit going on, all right, like, Brian has the right though to call witnesses, have direct testimony, have cross-examination. And there's something called an evidentiary hearing. You have the right to an evidentiary hearing. That's your right to be heard. So I get an email saying, bitch, you better be at the courthouse at 9 a.m. for this hearing that was canceled. What? Yeah. Okay, well, then I want to appear via Zoom too. Nope, they can, but you can't. No, you're wrong. Yes, I can, or they're not either. Your discretion. Okay. So I'm over here just like, the fuck is going on with the world, Like, damn, Ann Taylor's got, I'm over here just, motion for action on magistrate's decision. Okay. So I have a hearing, and I'm there for an evidentiary hearing, not to argue and litigate pre-trial motions that aren't even filed, such as res judicata and personal jurisdiction, which, wait, I got the email that says they're waiving jurisdiction, but yet we're going to argue it. The reason that they were letting them appear via Zoom is because they were waiving process. What the fuck? Well, that's not what they said on the record. In fact, so let me ask you a question. Go back to, if your husband beats the fuck out of you, okay, and you can't prove it, and his MO is to slap you around and punch you in the eye and punch you in the lip and throw you down the stairs, and then you go to file 6 months later, that your husband, again, did all this, but now you have evidence, okay, of what has happened, number one. And so you have material evidence, you have witness material to what happened. So much so that you have them there via Zoom to testify at this evidentiary hearing. Do you guys remember when Ann Taylor talked about you can't put the cart in front of the horse? Okay, meaning, did you get to Brian Kohlberger because of what was it? What is it here? Was it the FBI tip? Was it the Elantra? What the fuck? Where's your investigation? Where's your timeline of all these reports? Because when you look at it all, where's this tip? Where's this FBI tip? We went through all the tips. We can't find that tip. So I get up in the morning, fly down to the courthouse, and I have to lug all my fucking shit too. And here is what happened. There was no tip. I'll speculate. Ready? There's only one person on the screen. There's no lawyer. There's only one person on the screen. When I was told that there was a lawyer and this person, but here there's just this person. And Miss Oriani, are you ready are you ready? With an evidentiary hearing? Sure am. So-and-so, are you ready? No, I'm not. No, I'm not. I am just here so that final judgment is not rendered against me. A final judgment? This motherfucking thing was canceled because it was improper service because your alleged lawyer. Check this out. Check this out. Check this out. Let's see. Ooh. So, so I have a question though before I do this is if your husband beats you and you go and you write papers and you say, I'm here because my husband beat me again. No, you cannot. This is the same subject matter. You are not able to talk about this. You cannot argue this. I gave you 10 hours the last time we were here. Like, what? Those are all prejudicial statements right there to talk about the last time I was here. You have a prima facie to take on this claim with new allegations, new witnesses, and new evidence as what it is. So immediately when you hear anyone say, I gave you 10 hours the last time you were here, the fuck does that matter? So basically what you're telling me is that if my husband beats the fuck out of me again, it's the same subject matter. If somebody has an MO, they have an MO of how they try to get at you. Like, oh, well, guess what? My husband this time, you know what? He hired a hitman to do it, to come and beat me up. So I'm curious because I want your opinions on that. Like, how does a battered person go to the courts and say, hey, I just got my fucking ass kicked again. Oh, well, you were just here 6 months ago, and I gave you 10 hours to prove that this person kicked your ass. And this is the same subject matter. So I'm curious as to, like, okay, so what happens? Fuck you, Lana. Fuck all you women out there. Don't come back. No, if someone has an MO of kicking your ass, that's what they do. They punch you and they beat your lip, or right? No. Well, this time, he had his friend do it. He had his friend hit me. Woo-wee. Does that change it? Is that like, okay, so this is different claims? What? I'm just trying to understand, so let's take a look at this. Again, Okay, here, hold on one second. Testing, 1, 2, 3.
We are on the record on case number 23CB4944, Lana Oriani and versus Vanessa Walsh. Miss Walsh, I believe, is a Colorado resident, so she is appearing via Zoom link this morning. Miss Walsh, can you hear me okay?
Yes, Your Honor.
Okay, all right, so the parties are present in the courtroom. We are scheduled today for an evidentiary hearing on Miss Oriani's petition seeking a protection order to be issued against Miss Walsh. Miss Oriani, are you ready to proceed this morning?
Yes, I am, Your Honor. Can I just finish playing this one?
Okay, thank you. Miss Walsh, are you ready to proceed this morning?
No, Your Honor, I'm not. I'd like to address a few short things with the court.
Okay. Go ahead.
Okay. I do not believe that I was properly served. I'm not real clear why Ms. Oriani sent this to my lawyer's office. When I look at the complaint, it says it's supposed to serve me at home unless she doesn't know that address. As I'm sure the court remembers, we had another hearing back on January 10th, 2020.
Lies 1 and 2. Number 1, she was served where her unmasked business has an address. That's her business. Number 1. Number 2, according to civil procedure, you are allowed to serve somebody at their place of employment. That is law. So again, and she's saying that I served her at her lawyer's workplace, not hers. So lies 1 and 2.
3, and she did serve me at home for that one. She does know my home address, but I am here today because I didn't want a default judgment to be entered without me knowing.
But to be clear, you're still asserting the defense of insufficiency of process. So your presence today, because some people just go ahead and waive service. You're not doing that, is what you're saying. That you're claiming you weren't properly served, and so you're.
Okay, so check this out. Now, Lana gets to be a detective here. Ready? Last night we went.
Via Zoom link this morning. Ms. Walsh hearing on Ms. Oriani's petition seeking a protection order to be issued against Ms. Walsh. Ms. Oriani, are you ready to proceed this morning? Ms. Walsh, are you ready to proceed this morning?
No, Your Honor, I'm not. I'd like to address a few short things with the court.
Okay. Go ahead.
Okay.
There's Hector.
No, Your Honor, I'm not. I'd like to address a few short things with the court.
Okay. Go ahead.
Okay. I do not believe that I was properly served. I'm not real clear why Ms. Oriani sent this to my lawyer's office. When I look at the complaint,
Okay, so she's reading off of a teleprompt.
it says it's supposed to serve me at home unless she doesn't know that address.
Not true.
As I'm sure the court remembers, we had another hearing back on January 10th, 2023, and she did serve me at home for that one. She does know my home address, but I am here today because I didn't want a default judgment to be entered without.
The courts labeled it as not proper service, so there was no hearing. So there's no default judgment because there was no hearing. Or was my email communications making it perfectly clear on what the fuck transpired between July 20th and August 16th?
Without me knowing.
But to be clear, you're still asserting the defense of insufficiency of process. So your presence today, because some people just go ahead and waive service. You're not doing that, is what you're saying. That you're claiming you weren't properly served, and so you're appearing today to put that defense on the record. I just want to make sure.
Correct.
Okay, thank you. Go.
Okay, see, so right there, pause, 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 pause. Looking down at her phone.
I can wait. I mean, I am waiving service.
Now she looks at her phone because now she's getting her text messages and like, no, you're waiving. You're waiving.
I'm just explaining why I'm here.
Oh, you are? Okay.
You're explaining why you're here.
Sorry.
Yes.
Okay.
No, that's okay. Sorry, I might not have explained that well enough, but let me get the complaint here. So
I have to like go back to wherever, I'm getting my text messages.
Let me pull it up. All right. So I just want to address a couple of short things and ask the court to dismiss this complaint because it is the same subject matter that we met here before for the first hearing. Also, as it was decided last time, this court does not have personal jurisdiction over me. I think that the court could take.
That has nothing to do with this time. So let me get this straight.
Judicial notice of the complaint that Ms. Oriani filed back on October 18th, 2022 in case number 22 CV 7251 and this one that was filed on July 13th. This complaint and the prior one in January are about the same issues. Ms. Oriani has already litigated these things and she lost. She's just trying to relitigate them all over again. This is an abuse of the system, a waste of time and resources, and it's just taking a second bite of the apple. The court already ruled that she lost on the merits of her first complaint, and also that the court lacked personal jurisdiction over me. Filing this CPO shows that, in my opinion, Ms. Oriani has a lack of respect for the court and the previous findings. In the first petition, she says a bunch of things that includes me using third parties to hurt her. She says the gist of it is that I directed third parties to cause her.
This sounds like you're trying to bring up and relitigate the past.
Her mental distress. She says, she complains that I sent a process server to her home. In the new petition from July 13th, she makes the same allegations. Actually, I wanted to point out that above paragraph 1, in quotes, she has, quote, can prove now, end quote. So that right there is an admission that this has already been litigated. And then again, after paragraph.
Can prove now. Has nothing to do with anything from the past. If I can prove stuff now, I can prove stuff now. That does not mean that I'm talking about past matters. That is your interpretation of the document.
11, she literally says that she wants a hearing to, quote, prove allegations based on case law from last time, and I can now show the connection between Vanessa and all third parties, end quote. So right there, she's acknowledging that this is the same subject.
No, I'm acknowledging that the case law that was referenced in our last hearing, using that case law, I can now actually prove with my new allegations that they fit the statute. The only way that we're going to know that, though, is if we have the evidentiary hearing. So nothing can be a bite out of the same apple unless you hear it, and then you can assert that defense. But until you hear it, you can't assert that defense because it would be speculation. Let's see how I handle it.
Matter.
While she's on her teleprompts.
So there are rules on relitigating things that have already been decided on the merits. Ohio, a 1995 Ohio Supreme Court case called Grava versus Parkman, with a citation of 653 Northeast 2nd 226. Let me pull that up. Says that a valid final judgment rendered upon the merits bars all subsequent actions based on any claim arising out of the transaction or occurrence that was the subject matter of the previous action.
Now, that is not true. Now, according to Ohio law, magistrates rule Ohio Civ Rule 53, 4B, objecting to magistrate's decision. Action of court on magistrate's decision and on any objections to magistrate's decision. B, whether or not objections are timely filed, a court may adopt or reject a magistrate's decision in whole or in part, with or without modification. A court may hear a previously rendered matter, take additional evidence, or return a matter to a magistrate. You betcha fucking pretty ass it can. Civil Rule 53, 4B, 2 and 3.
So this court's already ruled on all of these issues.
All of
the court specifically found that she lost on the merits. The judgment was final because it wasn't appealed. And there was a ruling on the merits, and the court also found that based on our 10-hour January hearing that the court could not.
That your attorney argued for an hour and a half on personal jurisdiction.
Exercise personal jurisdiction over me. So I'm respectfully requesting that the court dismiss this case today based on the other case and this court's written order dated January 24th, 2023 in case number 22 CV 7251.
Okay, thank you. All right, so a couple things before I let you respond, Ms. Oriani. What I'm hearing Ms. Walsh say is that even though she does not believe she was properly served, she has chosen to appear and she's going to waive any defense of insufficiency of process. The personal jurisdiction argument, unfortunately, I have to use circular logic because there is case law that says if somebody has committed acts that amount to what's called menacing by stalking, then that's directed to an Ohio resident, then this court would have jurisdiction over them. And just like last time, unfortunately, I just had to have a hearing on whether there were such acts before I could determine if I had personal jurisdiction. So
that's precedent in this courtroom. So that's precedent to have the evidentiary hearing, which is also part of my due process 14th Amendment rights to have an evidentiary hearing.
You know, the two issues become conflated. So what I want you to address, Ms. Oriani, is Ms. Walsh's assertion of what, we call the
discretion here, wanting me only to address what she's asking versus everything that she just said. Okay. So number one is everything that she just said, I'm allowed to respond back to, not just what you want. That's discretion. And that to me is biased and prejudicial.
Defense of race judicata. She's saying that these issues have already been litigated and have been ruled on. There's been a final order that wasn't appealed, and therefore you are barred from, as she put it, taking a second bite of the apple and just relitigating something that's already been adjudicated. Do you have a response to that argument, please?
Yes. As far as that argument goes, I wrote in the complaint that there's new evidence that shows other acts of the menacing by stalking, with me being able to connect Miss Walsh to these people that I did not have before, that I did not know before. Miss Walsh also then took it upon herself to refile and try to get a contempt citation motion yet again to have me arrested, hauled into Colorado. And that was actually filed with her lawyer on June 26th. The motion proposed, her lawyer never even sent me the motion. I had to find out a different avenue. And in it, it says that the courts find no violation in these actions that would support a contempt of court citation. This protection order does not prevent defendant from pursuing a legal claim of action against plaintiff or the attempted service of the action. So at our last hearing, I was threatened by her attorney in court and said, if I attempt to call Miss Walsh to the stand, she will report me to the, she's going to write up another contempt citation motion showing and saying, because this is banned, like this, you're not allowed to have any type of communication contact with Miss Walsh. You cannot address her. So, therefore, if you do call her to the stand and question her, that's a violation of your protection order, and we will proceed, file, and you will be, held in contempt, which is criminal. So she, in a civil matter, is threatening criminal charges be pressed. That is misconduct. You cannot do that. Misconduct. Now, what I just read was the response when I didn't call Miss Walsh because of said threats, to the point that a magistrate cautioned me. However, not calling her, they still went and did what they did and filed a motion to do what? Throw me in jail. Why? Because I just read that what the court said is there is nothing, it's not contempt. Miss Oriani talking about the court's decisions, not contempt. Miss Oriani bringing on, legal matters, serving her, questioning her, not contempt. Okay? As an officer of the courts, she knew that, her attorney. I didn't know that because I don't know Colorado law. I'm an Ohio citizen. Now, and that's what they were trying to yet again harass me with, and they issued another motion to try to get me again picked up to be extradited, and then they wanted me they want jail time. So if that isn't menacing in one's life, I don't know what is, right? If and in fact you're doing it on false pretenses, if and in fact you're filing within affidavits false things to then have that happen, that's menacing. How is it not? Again, I put on my motion or my petition that there was new evidence
new witness that links Miss Walsh directly to the acts, and we need to have that hearing here today to see if that,
Links her to the acts
of menacing by stalking.
that you were trying to prove last time.
No.
But now you have a new witness.
No.
I have a new witness, but additional.
What new acts other than the June filing?
Well, that's what an evidentiary hearing is for.
There's the June filing.
That's what an evidentiary hearing is for, right? And I just read off what happened. The June filing and what else? Let's hear.
And then her admissions of how everything went down with I never had her on the stand, so we didn't get to address anything that has to do with the first citation motion. Never got addressed. I never got to have her on the stand. I chose not to based on me not knowing. I did not want to get any type of trouble. So therefore, things were not brought up at that hearing that were supposed to, in addition to what has been uncovered new.
But I'm specifically asking uncovered new.
Why would I testify to what it is if it's not from me?
January.
Mm-hmm.
The hearing was in January, correct?
Yes.
Okay.
Yeah.
So what new acts have happened since January? You told me about this June filing. Or have there been other new acts that you want to talk about?
He's just totally doing himself here.
Her name is telling her and waiving her client.
Okay, here.
A woman here that's set to testify. Her name is Amber Forte. And she's testifying on Miss Walsh telling her and waiving her client attorney privilege with giving her information that her lawyer gave her on how they were going about stuff with her lawyer, saying that I was contacting her and her lawyer multiple times a day. She was being contacted that I was a coke addict, that I poisoned her dog again. She used her YouTube channel to put this stuff out on the internet.
Okay.
I'm not supposed to be talking about any of this, just so you know. I'm so mad right now. She, no lie, wants to like send someone to my house or whatever. She wants me in a courtroom and basically said that she can force me to be in there. And because of the PPO, apparently she can't. That's like, she literally can't ever subpoena me, put me in a courtroom. She can't force me to testify. She can't get that through her head, and she won't admit that. And in July, she was asking to write me a letter or call me, and they had to explain to her again. Dude, I don't think she understands what a PPO is. I don't think she's ever read it. And she said something about she could fix this with a phone call or something, like she can get on the phone with me and change her mind. Here's the funny thing is James isn't lying. Like, I don't like to fight with people. I am very I like to get along with everybody and just be friends. I don't like conflict, right? So I would have, had she just, God knows, I might have felt bad for her and dropped it at some point. And I'm serious, but there's no way in hell I will die with that thing active. She is, the minute she put my kid in the mix, she's done. And no, she contacted my lawyer, and my lawyer finally had to threaten to throw her in jail last week because she's insisting that she has control over me. And because she's pro se, I have to talk to her. And my lawyer's like, you will never talk to her again. Jesus. And again, I'm not even supposed to be like, I don't know. I keep my mouth shut about everything, but I think it's obvious at this point that there is a detective. She knows there's a detective. He actually gave her his name and number, but she's never called him. So she knows damn well there's a active criminal investigation, and it did go up to the DA, and they are concerned about it. The only issue that's the only reason she's not in jail right now is because she lives in Ohio. But that's not going to trump them thinking that she can send people from the internet to hurt my daughter. That's where she fucked herself. That's what they're concerned about, like very concerned about. And she just did it again, like a dumbass. She threatened everyone tonight. She threatened Sarah. She made comments earlier. I'm recording it if you didn't see it. I missed you on panel. I'll go back and watch. She said something about your probation officer and that they have to report violations. She's just threatening everybody. Then proceeds to threaten James. Then proceeds to threaten my daughter. And I get that. I'm a reasonable person. I mean, do you understand? Like, I did not plan for her to get served on it. That's, if you hear her in the background, I have to record her for the detective. I hate listening to her voice. I was laughing so hard the other day on your live. You were talking about how you can't stand her mouth sounds and that she eats her microphone. And I was like, finally, someone who feels my pain. I have to record her, and I cannot stand the way she talks. And I've come to like hate the way she holds her mouth, the way she speaks, the way she talks into her microphone. I was dying laughing. Anyway, I got off track. Anyway, don't, if you put yourself in any risk, don't feel like, you got to get involved or anything. I told James, because I was on the phone with him, I'm like, hey, she's threatening Moon, and he was pissed too, but I don't know if she's seen his community posts yet, his new ones, but I would always vouch for if I don't even know if that would help, but to explain the situation that I have a restraining order on her and she's retaliating against a bunch of people that are in contact with me. I don't know if that would help, but I would definitely do that. But I'm a reasonable person, and I realized I did not try to have her served on her live. That guy, who I picked from Google, by the way, the reason he did that was because he was like, I got to drive an hour to her house. I have a friend that lives in Grove City. If I'm going to drive down there, and he goes, he's subbed to both of our channels, right? And I didn't know anything about the guy. And so, until later. And then he saw her ad. Like, we were on the phone. He goes, oh, she has an ad up for a live tonight. And I was like, oh, yeah, she has a lot of those. And it wasn't even clicking for me because I was so stressed out. Well, he was intelligent and was like, hey, I'm going to come to her house when I know she's going to be home. And she advertised the live. That's why he sat there and did that. I did not know until about 5 minutes before it was served. And I was having a freaking panic attack. I was like, oh God, because I didn't expect that. And I was like, oh my God, this is going to be a circus. Everyone is going to see this. But he was like, hey, heads up, I'm outside, I'm going in. I was like, oh God. I even messaged him and I was like, hey, heads up, she's live. And like an idiot. And he's like, I know, I've been watching it. And I was like, oh God, you're going to serve her on the live? And he's like, yeah, I'm here. So that has nothing, I mean, anyone's opinion about it, they can have their opinion about it. Did I think he knocked really hard? Yeah. But that has nothing to do with me. I didn't know Jax is there. I think Jax is fucking adorable. I love kids. That broke my heart, actually, because I was watching. It broke my heart when he sounded scared. And I knew what she was doing. And I was like, Jesus, Lana, for once, just do not drag him in. Like, just act normal or blow it off or act like, oh, it was awful. I was freaking out. I felt terrible. I mean, I was like nauseous. So I'm not like that. Okay, she is. I would never want Jax to be scared or sad. She made that as miserable as possible. She could have turned off her camera. She could have been like, oh, it's just papers for mommy. That's what I would have done. God, you can hear her like yelling like a psycho. But I mean, she had to make it scary for him. It's like, that's a selfish mom. I would have been like, oh, no worries, honey. Go out, play. Like, it's just some papers for mommy. Like, that's what I would have done.
papers? No, the guy said he was broke down outside my house. He didn't say he had papers. 5 minutes beforehand, my son was right there. Too bad the digital evidence shows otherwise.
To have my child taken from my custody. And that she is saying that she's working to have my child taken from my custody. Have my child taken from my custody. And that's continuing.
Your Honor, am I allowed to respond?
Give me 1 second, of course. Are you done? Anything else, Ms. Oriani?
It's a pattern of behavior. So this is different acts, and it's a repetitive pattern, and that's menacing by stalking. That's what the definition here is. And why I didn't have personal jurisdiction last time is because I couldn't prove any damages that she had done. This time I can prove, as an Ohio resident, I was damaged with her actions outside of the long arm statute, which it reaches.
Okay. Ms. Walsh?
Your Honor, the only pattern that's been established is ever since I've received, that I was awarded the restraining order in Colorado, she has been trying to get revenge for it and has been dragging me through the court system while simultaneously breaking the restraining order and continuously stalking me. She just gave you an example by contacting people that have spoken to me. She's not supposed to be doing that with the restraining order, contacting people I've spoken to and obtaining private conversations that are supposed to be private between two people, that the only interaction that Ms. Oriani and I have is.
This is pure speculation, argumentative, and I didn't testify. I'm acting as my attorney right here, explaining why I have a witness with corroborating evidence, and it's their evidence, not mine, right?
Is in this courtroom when she drags me to court. And if she does have a problem with something and she thinks there's something that should be litigated, she should be doing it in Broomfield County, where the evidence has been heard, where this has already been litigated, and where she willingly availed herself to their jurisdiction.
Okay.
You can hear when she's speaking to you, she's grasping for straws, trying to come up with stuff that's new. She just gave 3 examples that I heard specifically of things that we already litigated prior. She just admitted it's to get me on the stand because she didn't do it last time. That's unfortunate for her, but things turned out the way they did. She also wanted to redo the restraining order hearing in Colorado, lost that appeal. It's not right to abuse the system in this way, to punish me for getting a restraining order when that judge found she was a credible threat to my life and the life of my family. And she's already put me through enough the past 2 years.
I wonder how that judge feels now. We'll find out. 2 to 6 purge.
I find this a blatant abuse of the system.
Look at this idiot.
No, I did not appeal that.
Okay, so that is a final ruling under the law because you never took
Correct.
an appeal. Okay, all right. Just want to make sure that was on the record. Okay.
Yeah, Your Honor, I'm here for new allegations.
I understand.
Appeal that.
Okay, so that's
Right here.
be said right now. But my initial ruling is that Ms. Walsh has properly asserted the defense of res judicata, and
It's impossible. My fundamental right there was denied, 14th Amendment right to be heard, and that would require me being able to due process. So in turn, let's see what Lana did. Motion for action on magistrate's decision. Let's see. Well, let's take a look at that process server again that never got to be played in court. Let's see. Let's see. What was it? She wanted me to just take these papers? What papers? There's no papers. Interesting. Oh, those were that was just 6 minutes of her pressing the button to record herself and within text messages and send them. She proceeds to talk about how her attorney told her all these things and proceeded to say that her attorney was telling her all of these things. And in turn, she was telling a third party, and then a third party was putting them out on the internet. Well, once you tell a third party what you talked about with your attorney, you waive client-attorney privilege. So it'll be very, very interesting. And I believe that is why, dun, 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 she was there by herself without this attorney who's always been there. It's because I brought it to the forefront and I motioned to the courts and I said, comes now, motion for action on magistrate's decision. I'm a pro se litigant and ask this honorable court, pursuant to Ohio Civil Rule 53B, action on magistrate's decision, whether or not objections are timely filed. A court may adopt or reject a magistrate's decision in whole or in part, with or without modification. A court may hear a previously referred matter, take additional evidence, or return it to the magistrate. Specifically, petitioner is asking that this matter be returned to Magistrate Griffin, where an evidentiary hearing can be properly litigated without petitioner having the deck stacked against her, due to petitioner not being able to use material evidence and testimony that was withheld by petitioner due to respondent's counsel's blatant courtroom misconduct. Respondent's counsel, Ms. Zimmerman, displayed unethical intimidation tactics during the court proceedings that directly affected the outcome of the hearing, as stated by Magistrate Griffin within her findings of facts dated January 31st, 2023. In quotes, the magistrate ruled on the record that petitioner's evidence was insufficient to meet her burden of proof. This conclusion was not reached lightly. It would have been preferable for the undersigned to render a decision based on a fully developed record. And upon weighing the merits of evidence presented from both parties, if respondent had presented a defense, the undersigned would have been in a better position to render credibly based conclusions. Ms. Zimmerman's threat of criminal prosecution during petitioner's separate civil matter resulted in petitioner being denied her 14th Amendment right to due process. Petitioner had the fundamental right during her civil action in Ohio to call any and all witnesses and cross-examine those witnesses without the threat and intimidation tactic used by Ms. Zimmerman. Ms. Zimmerman, while representing respondent pro hac vice, was held to Ohio rules of professional codes of conduct, which she violated while representing respondent in open court. Petitioner says, in quotes, intimidation tactic, because that is exactly what it was. Because as it turns out, had petitioner known that she could not be held in contempt for bringing legal action against someone that had a protection order against her, she would have most certainly called respondent as she intended to the stand and respondent's counsel. See petitioner's Exhibit 1. Exhibit 1 shows that after petitioner obliged by Ms. Jennifer Zimmerman's tactics and did not call respondent as a witness on January 10th, 2023, that Ms. Zimmerman and respondent still attempted to deceive the Colorado courts with known falsehoods in a second citation motion seeking the arrest of petitioner. This mere fact that Ms. Zimmerman filed the second contempt citation motion on June 26th, 2023, for respondent's arrest is proving additional direct evidence of the continued pattern and agenda of Operation Takedown Lana Oriani. Ms. Zimmerman is Ms. Zimmerman is a partner and has been practicing Colorado law for years. Her pattern of repetitive misconduct while in Ohio should be worth judicial notice by Franklin County courts. Petitioner's right was deliberately and methodically infringed upon by Ms. Zimmerman, and so therefore petitioner objects to Magistrate Griffin's court findings of facts where Magistrate Griffin downplayed the communication exchange of Ms. Zimmerman on January 10, 2023, and the immediate mental effect that it had on petitioner. So much so that petitioner's mental distress caused her to unknowingly violate her own 14th Amendment right. Petitioner knew respondent and her counsel, Ms. Zimmerman's goal to wrongfully imprison petitioner were very much a real daily living nightmare, and only Magistrate Griffin cautioned petitioner with how she proceeded. Petitioner then believed that she didn't have the fundamental right to question respondent. Magistrate Griffin to imply that the petitioner seemed, in quotes, confident and had a choice are not issues of fact, but of opinion stated by Magistrate Griffin. Petitioner asks this honorable court to award petitioner her 14th Amendment right, which was violated by opposing counsel, Ms. Zimmerman, by overruling the findings and issuing a new evidentiary hearing where all material evidence and witnesses can be heard and seen by Magistrate Griffin. Then I took a page out of Ann Taylor's book. I did a declaration. Declaration of pro se litigant. I'm declaring. Petitioner was grossly intimidated by an officer of the courts, i.e. respondent's counsel, Ms. Zimmerman, on the record multiple times during the above captioned case. These threats of criminal contempt while litigating a civil matter is the definition of misconduct. Ms. Zimmerman, who received approval to represent respondent pro hack vice, made these misleading threats as a way to continue aiding respondent's efforts to dodge taking the stand under oath. Petitioner anticipated material that would impeach respondent's previously sworn statements, hereby discrediting respondent while also connecting her directly to the menacing acts through exhibits that were not able to be presented due to petitioner not calling respondent to the stand. Petitioner made this decision so she could live free of mental distress, but in turn, Ms. Zimmerman filed for a second citation motion of contempt on June 26, 2023. And again, Ms. Zimmerman and respondent were not truthful in their sworn statements within that motion. This is a pattern of behavior that is menacing in petitioner's life. Ms. Zimmerman's misleading threats caused the finder of fact to caution petitioner, which led petitioner to believe that what Ms. Zimmerman was saying held merit. Petitioner purports that Ms. Zimmerman's purpose for the unethical and incorrect assumptions of the outcome of reporting petitioner to Colorado was to intimidate petitioner, which would cause petitioner to violate her own due process. To call Ms. Zimmerman's client, respondent in this case is a witness. This unethical stunt in turn violated petitioner's right to due process, as petitioner was unable to call her star witness respondent in the above captioned case. As an officer of the courts, Ms. Zimmerman's ignorance of the law and Colorado state statutes are inexcusable and are not of viable defense as her intimidating pro se litigant. Petitioner further asked this honorable court to conflict out Ms. Zimmerman for being able to represent respondent due to Ms. Zimmerman's proven courtroom misconduct on January 13, 2023. In the alternative, petitioner asked that Ms. Zimmerman be issued a subpoena to attend and produce all phone records and digital communication timestamps and dates, not the material within the information. Now a new motion, objections to case number blah, blah, blah. Comes now pro se litigant and objects to the interim decision of Magistrate Griffin in regards to the above captioned case. The petitioner was denied her right to be heard on August 24, 2023, when Magistrate Griffin denied petitioner's right to due process, which violated petitioner's 14th Amendment right. This palpable violation does not stand alone, and therefore petitioner raises merited detailed objections that support petitioner's efforts in questioning the integrity of the decision to violate petitioner's 14th Amendment right. These objections come in the form of prejudicial statements biased decision making, unethical and improper communication between officers of the court, to include respondents' counsel, and procedural errors. Petitioner's objections are outlined and attached here to as Exhibit A. Within Petitioner's Exhibit A, petitioner raises numerous objections and prays that the courts afford petitioner her fundamental right under the Due Process Clause to be heard through an evidentiary hearing by an impartial finder of fact who can render a fair and just decision based solely on the facts presented before the finder of fact, and if the allegations and damages meet the threshold to be remedied within this avenue of the Ohio court system. Factual background. Let's see. See. Oh shit. Hey, you still there? Boop, boop, boop. Okay, cool. Whoop, whoop. That name of that song is Wig Off. Hey, what's up? Hi.
Hello.
Hello.
Hey, man.
Hi, how are you?
Good. How you doing?
Good. I'm trying to turn you up. Let's see. Nothing. We were actually talking about your case because I was comparing your preliminary hearing. Everybody, this is Dave on the phone. So here, hold on one second. I'm trying to turn you up. So just, talk loud if you can. We were talking about preliminary hearings versus grand juries. You didn't have a grand jury, right?
No, I had a preliminary
Okay.
hearing.
And when you had your preliminary hearing, how soon after did you get the transcripts of that preliminary hearing? Couple months?
5 months.
5?
Yeah.
Okay. 5 months? Damn. How long? Wait, then when did you then go to trial after that?
Go to trial?
Yeah, like how long? So you had when you had the temporary.
I went to trial September 14th, something like that.
And when you did your voir dire with all that, weren't there issues with that?
Yeah, with the jury?
Yeah.
Yeah, with the juror lying on his questionnaire?
A juror lied on his questionnaire?
Yeah.
What ended up happening? Did you guys catch it? It was caught after the fact?
It was caught after we had put the jury together. So once we put the jury together, he came back and said, and told us that his wife and stepchildren was kidnapped and held at gunpoint.
Wait, his wife and child were kidnapped and held at gunpoint.
Yeah.
And he was on the jury for your case, which had to do with a robbery with a gun
And kidnapping, yeah.
and kidnapping. Wow. I mean, I think that's kind of prejudicial.
Yeah, but McBride refused to let him off the jury just because he said he might. He's somewhat okay with, like, he could be fair and impartial.
But he lied though and said that he never disclosed that though, right?
No, he never disclosed that on his questionnaire because it asked you, have you or anybody in your family ever been a victim of a crime? He said no.
How did you guys end up finding out that he was held at gunpoint? How did you guys go about?
He came and told the court reporter.
He told the court reporter?
Yeah. Or the court, the bailiff or somebody, he told him when he came in for jury duty.
Interesting.
So then we did more there on him. And they asked him questions and he said that he was just coming into the relationship, so he really didn't think that it mattered. But he was there throughout the whole process of it. So whatever transpired with that as far as the court.
I got you.
And that person and all that. But he yeah.
Well, did you know that? So they're doing a really good job campaigning right now for Nate Bible for the district attorney's position in Beaver. Do you know about this? His name's Nate Bible, and he's running against DA Lozier, and he's doing really good right now in terms of because that election's coming up in November, so we've been pushing hard to get Nate Bible to be able to take over as DA.
He's a Democrat or a Republican?
He's a Democrat.
So he's running against.
Yeah, he's running against Lozier.
Yeah.
Which I mean.
Yeah, I never heard of him, but I mean, I think a lot of people feel that Lozier should be removed.
Yeah, we just have to get people out, to vote. So I was like, should I rent a bus and get a barbecue going and bus people down to vote? We did that back in the day, back in Cleveland, and it helped with like the levies and stuff passing for school. We got the people out from the apartments to go vote because it didn't change their, they didn't pay taxes. So, it was, but if you can get somebody, if we can get somebody into that position that would, be even open to, hey, looking at this.
Securus. Goodbye. I'll call back.
Okay. Yeah. So I don't know if you know that, but yeah, write that name down, Nate Bible. That's who we've been pushing for. He's running against DA Lozier, and I think he has a pretty decent shot. I know that he would win if we can get people out to vote. I mean, DA Lozier just pulled that stunt with Rachel Del Tondo's case. Okay.
Hold on one second. Hello?
Yeah.
Hey, what's up? I can hear you.
All right, what were you saying now?
Oh, no, I was just talking about that November is a huge election with the district attorney position.
Yeah. Yeah.
So we need somebody in position to campaign against him.
Well, Nate Bible's already, like, he's the one that's running, and they've been doing a pretty good job of campaigning. We just need to get people out to vote for Nate Bible. So that's what I'm trying to put together, is to, like, so I know your mom's always up for ideas. Let's get her on renting some of those vans, bussing people down there to vote.
Yeah, we definitely could do that. That's something that could definitely get behind and push for.
Yeah, because they're able to, you know, when you have a district attorney that's going to look at something and versus somebody that won't even like look at your stuff, you know, push for that with the judge. You know what I mean? Because McBride's no longer your judge, so you have a different judge. If you have the backing of the district attorney's office, with, I think that'll go a long way. And I just don't see that happening with Lozier, as we talked about. But here's our opportunity to try to do that.
What did Nate Bible do before running for office?
That's a good question. I mean, they're all involved with politics. Let's take a look. Well, he's a lawyer. He's a divorce attorney. Did you use him?
No, I ain't use him, but I for some reason his name sounds familiar though.
That's funny. Let's see.
So yeah, that'd be a good thing. I could talk to my mom and talk to my family about it.
Yeah.
So we can start getting the motion right now.
You're in a motion right now?
Huh?
You said wait, what'd you say?
I said start putting things in motion now.
Oh, okay, yeah.
Yeah, about 2 months.
Yeah, it's 2 months. 2 months. You know that guy, I forget who it was. Was there any luck at finding the rest of those phone records from Brandon Morgan?
This is a call from Pennsylvania State Correctional Institution. Green. This call is subject to recording and monitoring.
You say, what about the phone records?
Was there any luck in like getting more? Like, you know how I told you they had some of them?
Yeah. And I looked at my legal work, and that's all that they gave me.
Okay.
I guess they gave from the time that you did that you start speaking with me all the way until the commission of the alleged crime.
Okay. Let me see.
I think that's something that might have to continue the phone company for.
Let me see. Did Bauer continue to represent the one kid?
Reason?
Yeah.
I mean, he represented him through his plea deal.
Through his deal?
Yeah, all the way through his plea deal, and during the testimony he was there.
Okay. Because did he testify at your hearing?
He testified at my trial. He was my co-defendant. He was the one that was with me the whole
time. When you guys had your
preliminary hearing, and you know how they did a continuance with him to be able to be dressed differently, or you guys got to all dress differently?
Yeah.
When did you guys reconvene?
The next day.
This is a call from Pennsylvania State Correctional Institution. Green. This call is subject to recording and monitoring.
They just didn't want us to all have on the same. I guess me and Revis had on green and white, and the other two had on the orange and white. But they only did that because Brandon Morgan picked out Revis as being suspicious of signal.
Yeah.
So they tried to make it seem like that's the reason he may have done that. But me and Revis look nothing alike.
No, you guys are totally different. Do you have any emotions in right now?
No, nothing now. I just had my commutation in. But that doesn't affect any emotions that anything that you do before.
Has anyone ever came to you and asked you if has anyone ever asked you if you would testify in another case that they would work or do something about your case?
They had when I was about to pick the jury, they had asked me, they had told me if I told them where Michael Ross was, that he would give me a plea deal for 7 to 14 or something like that. And I told them no, pick the trial, pick the jury.
They wanted you to cough up where Michael Ross was?
Yeah.
What was going on in his life at the time?
I think he was on the run for a homicide.
Was that during the Jamie Brown case still? Like, did that carry over?
No, that was around the same time as my case.
Okay. So the deal was, if you said where Michael Ross was, they'll give you 7 to 14. Did you hear Sheldon's getting his evidentiary hearing?
Yeah, I've seen that. I also seen Lozier come out now all of a sudden before election.
Yeah.
To name him as the prime suspect.
Yeah. He said he's going to release search warrants. He hasn't done it yet. That was his political move. Rachel's parents came back and went at him. So basically saying get fucked, more or less.
Right.
You know, they're like, you're not going to use our fucking daughter to push your, campaign, act like you give a fuck. We know you don't give a fuck. You didn't even done shit for our kid. And I've always said if the Del Tondos and the Jeters, if they rallied together, shit could happen. Because Beaver's to blame for all this shit, but Al Clipper cops not doing their job.
But that's a systematic thing. That's in everything that they do.
Yeah. Hey, so that gun that they said that you had, but there was no gun in evidence or anything like that? Did they ever have a expert witness to talk about the fact that the window was shot out versus like punched out? Is there any?
No. They never had an expert witness present the gun at all.
How many times did you meet with your lawyer before you had trial?
None.
None?
No. No, one. I did. Maybe one.
One time?
Yeah, I met with one right before trial.
Right before trial. So he never came down and asked you what happened?
Right before trial. We went over everything, and he had me write a statement as to what I would say if you understand. But no, any correspondence we had in the mail.
All your correspondence was through the mail. So you're in county. He never comes to see you. Did you ever see your discovery before you went to court?
Yeah, I got my preliminary hearing transcript.
No, that's not discovery. Well, what besides that?
I got a couple. I got majority of the stuff that he had. Other stuff, some stuff that after trial I got that I didn't know was in there.
Unbelievable.
But no, Danielle didn't come down there and visit like this one time.
So there was this gun. No one's ever. So you got charged with a gun charge, but yet there was no gun in evidence.
No, and testimony about whether or not there was a gun or a cell phone.
Did they ever test you for gunpowder residue?
No. And they picked me up the next day.
Yeah. What?
You have 1 minute left.
Trying to think. Did they have the casings? Any casings?
No casing.
No casings?
No. In the car or outside the area where it when it was shot out.
Let me see. No casings, no gun. Because that's what the problem is here. That's what otherwise you'd be like, how many years was on the gun charges?
It's a mandatory 5 years.
Thank you for using Securus. Goodbye. No call back.
Is it a mandatory? What was it? 5 or 9?
5. So he'll call right back.
All right, babe.
There you go. Hold on.
Okay. Oh yeah, guess what? Okay, so that was our thing. Remember how I said we never got the 911 call from when this girl called 911? Her name was Brittany. It's new evidence. So he can bring forth his case. You there?
Yeah.
Okay. So you can bring forth new evidence at any time. Like, you know that.
Yeah, I can do it second subsequent CQRA.
Yes. So the 911 call that was made remember when they went, let's see, right here. You go there and they said they called the police. That 911 call has never been coughed up. It was never put in anything.
Yeah, I didn't see no paperwork or evidence on that.
Because the 911 call of when you guys went to Palouse Apartments, I believe that that's going to show a totally different timeline, which is material in what then they are saying how much time would have elapsed.
Right.
Let's see.
Oh, and there was a second. There was another order on the jury. I forget about that. That's when the mother and father had
Okay, so what was the day of the offense? Is it on the? It was the. What was it?
the 16th.
But like the 15th going into the 16th?
Yeah, the 15th. Well, yeah.
Yeah, that's what I mean. Okay, because paper. Oh yeah, here we go. Got it. Okay. 15th going into the 16th, right?
Yeah.
All right. Remember how I told you I went through all the numbers that were ever called that night? So he said that this all happened around like 10, that they met you up.
Yeah.
He testified that Brandon, went to work and was at his apartment. Remember, like, that he never went into Aliquippa. He was never there.
Right.
This is a call from Pennsylvania State Correctional Institution. Green. This call is subject to recording and monitoring.
Well, all he's doing that day is like let's see. He doesn't use his phone that day from 6:54 a.m. until 1:20 p.m. on the 15th, And remember how I told you that on the 14th, he was in Aliquippa. Yeah, but remember when you said that this was originally supposed to happen? And then it got pushed back, like a meeting with when was this whole drug deal supposed to happen originally?
The thing about it is, I wasn't a part of the original deal.
Yeah, I know that. That's what I'm trying to say is, but what?
I didn't find out until that night, until that day that I was with Revis that night, and Marcus and them pulled up. That was my first introduction to that deal, this totality. But from what I gathered after the fact was that this deal had been trying to be worked out for 2 months at least. I was in Atlanta at that time.
Okay. Well, Brandon Morgan was in Aliquippa all fucking like he was there. He was in Quip all day. Like beginning from well, he was driving back and forth, but his first that was like I think was it a Tuesday or a Thursday that this happened?
This is a call from Pennsylvania State Correctional Institution, Green. This call is subject to recording and monitoring.
Yeah, somewhere in the middle of the week.
He spent the night in Aliquippa, I'm telling you, on the 14th. And that's what I've been working on is figure out who the fuck where he slept on that night, because if you don't call at 6:30 in the morning, 6:35 in the morning, you don't call your the neighbor Missy, you don't call her to get in touch with your girlfriend, because she doesn't have a phone at 6:35 if you're there with her. You know what I'm saying?
Right.
And his last known whereabouts on that 11, he was in Aliquippa. And I just believe that he spent the night. But anyway, he didn't use his phone from 7 basically until 1:30. And then at 1:20, 2:40, 3:15, 5, a ton of phone calls at 5. And that's when he started calling that Brian dude.
Right.
But see, when somebody was with him, I believe, in Aliquippa that he picked up at 3:15 because he was in Aliquippa making a phone call. And then, it's right over the bridge. So then he goes back across the bridge and he's in then South Heights, which is Ambridge, right?
Yeah.
At 5, 5:03, 5:06, 5:08, 5:07. And then he's boom in Aliquippa at 5:08. So it's like he gets in his car, makes a phone call at 5:01. And as he is traveling to come back over the bridge at 5:08, he is making then another phone call, which pinged off of the Aliquippa Tower. Then he goes back over to Ambridge because he's there at 6:12. Then 6:20 back over in Aliquippa. And then 6:23 back. He's in Aliquippa. And then do you remember that?
Does it say the first time he called from Rochester?
That day?
Yeah.
Yeah. When he got a call from Rochester, because he was never in Rochester.
Or he received a call while he was in Rochester.
See, that's the page. That's what I'm missing. I'm missing the nuts of it.
Because that'll tell you the time that we got together.
I don't have. I went through all my stuff. That second page I don't have, but I mean I'll look again, but
I think there was a girl in Aliquippa. Did he say anything about a girl when they were all fighting and arguing?
No.
Did he act like he knew where he was at when he was driving?
Not that I can think of.
Did that girl say like he cheats on me or anything like that?
Yeah.
She did?
Yeah.
Yeah. Because he was. I'm telling you, this motherfucker was banging somebody that lived in Aliquippa. He's there at nighttime and stays there until at 6 o'clock in the morning. And he probably just tells her that he got too fucked up to drive, so he didn't drive because he had a bunch of DUIs. You know what I mean?
Yeah. And Rashad lives in Aliquippa as well, though.
God. I just can't believe that a lawyer didn't even, I can't believe that your lawyer just didn't even fucking look at this. This just pisses me off.
Yeah, no, that's not even something brought up as far as the phone record.
They never even brought up the phone records to call him out to be like, you're in Aliquippa all the time. He testified and said, I don't go to Aliquippa. Motherfucker, look at your phone records. You're in Aliquippa like every day. You drive back and forth. You are a drug dealer, man. Who drives like this? Who goes all across? Like, this is what your phone records show you. You're driving all over. Like, by the minutes, it's hitting off of different towers. Like, this is, you just look at this for a second, you know that. And then all he had to do was fucking call. So, it's not considered new evidence. You know some guy named Nate? Ever hear of a Nate?
Is he in my paperwork?
Yeah, this is who. He said, I was supposed to take them to this guy on Saturday night. Let's see. He said he could leave the house because his girl left him to watch his 2-year-old daughter. You weren't even in town on Sunday night.
No, I didn't get. I was only up Friday.
Okay. See, he says. Okay, so he writes in his stupid printout that Mark Way called him. He said, this led us into Tuesday, November 15th. It was around 5 o'clock when Mark Way had called me. Then I compared those to the phone records that I had. And because he wrote this up after the fact. And so that phone call would be, this is a incoming versus outgoing. Let's see. Right here. Incoming. That's this call right here. So all you have to do, what I did is that this is not your number. So all your, when I was just like, you asked me on the stand, okay, you said he called around 5. Is it this number? Is it this number? Is it this number? What number did he call you from? Like, so Jerry Benio did not talk about any of this? The fuck out of here.
Yeah, that wasn't even in their line of questioning. That's not even something he brought up to me.
Because then they would look at it and say, okay, that's not your number. That's not your number. None of these are your number.
Right. And it could have showed that I wasn't the ringleader, that I wasn't a part of this initiative.
Well, because he's saying you're Marquay, right? That's your nickname, right?
Yeah.
Yeah. It was around 5 o'clock when Marquay had called
Thank
me
you for using Securus.
and
Goodbye.
it said he had the 7,500 and wanted to meet up with this kid. I told him that I would call Otto and see what happens. I talked to Otto and he told me to meet up with him in New Brighton around 10:30 or 11. I called Marquay back and he told me he would be in Rochester and where he would be at. Now, that means that Marquay called him at the 501, or it had to be one of these numbers. Okay. And then when he says that he called Otto, after he talks to him, then one of these had to be Otto. So then you'd fucking haul in Otto or one of these Otto. You know what I mean? I let Jamie and Missy know what I was doing. No, you didn't. Both of them said that they wanted to go. Who the fuck would want to go do a drug deal, 2 girls, to make sure that nothing went wrong? Because they're the muscle. The fuck out of here. I cannot believe that anybody would fucking believe this shit. He didn't even put any emotions in for him. He didn't do shit for him. Two girls gonna go with me to. Once in Rochester, I called Marquay and asked where he was.
Hello?
What's up?
Yeah.
Hey.
I meant to tell you too, right? There was 2 more there too.
Yeah.
When the mother and father talked to the 2 jury members.
Yeah. And there was wasn't there like that fight or some shit?
Huh?
Was there a fight or something, like people got rowdy?
No, that was when after a day of deliberation, they was in the parking garage by themselves.
Yes, that was at the parking garage.
Yeah, and the mother and father spoke to the 2 jury members, and they said that they was helping them fix a dead. One of the jurors had a dead battery, and they came and found him guilty the very next day.
Shit. So then I was like, okay, have you filed a motion to reconsider? Because I'll help you write this, because the motion to reconsider, if you use the evidence to show that, did you ever use exhibits when you did a motion to reconsider, or how,
No, it was a 1-page motion asking them to hear me out. I filed it up on those, and they denied it. They said they don't have jurisdiction.
who has jurisdiction?
Nobody at this point, because I'm no longer in the appeal stage. But they could hear it, even though they don't have jurisdiction. I could have filed the Superior Court and asked them to give them jurisdiction over it. Could appeal the denial of the reconsideration. But I don't think that it was officially done.
If Rashad Brown testifies, that's new evidence, and that's grounds for you get. But you'd want affidavits with them. So, and then if
This is a call from Pennsylvania State Correctional Institution. Green. This call is subject to recording and monitoring.
If Rashad Brown come and say that no, it wasn't me that he was talking to every day, no, it wasn't me that he set the drug deal up with, and all that, then that's newly discovered evidence because it was never presented to the jury.
yeah, well, also with as much as heat as Couch was under, Couch was involved in this, and he got fired. Okay, for improper shit. That should be included in what you're talking about, because He was actually present for testimony.
Yeah. I mean, all you got to do is find one thing that can get you in the door. Once you're in the door, that you could use all the evidence that you need to in order to further your argument. It's just about finding that one thing.
You have like 50 things. I mean,
yeah. But you need that one thing to get that newly discovered evidence so that you can get in under that right? And once you're in, then you could pretty much argue your whole case again.
yeah, it's got to be material that would have changed the outcome. And I think that Rashad Brown saying that that's not who I fucking know is newly discovered material and would have changed the outcome.
This is a call from Pennsylvania State Correctional Institution.
But-
Green. This call is subject to recording and monitoring.
Yeah, because
But I also believe there's it's like Brady in a way, because it's Rashad Brown was contacted by what's his name? Timothy.
Patrick.
Yes. And that would be, how is that not Brady? You'd have to ask Rashad Brown what he said to Patrick.
Because he was a part of it. He was the ringleader for real. He was the one that put it all together.
Oh yeah.
The middleman,
Who was?
Rashad Brown. He tied both parties together.
Yeah, that's why I'm saying, how could he not fucking be called to the stand? How is he not the one to be testifying as to how all this transpired? And I believe it's because it was buried. And that's, to me, that's Brady. They had it. Especially if we have, if Brown says, I told Patrick this, if I say, hey, this is what your report says, did you ever tell Patrick this? No. Do you know this guy? No, I don't even know who this fucking kid is. You know what I mean? Like, does he know you?
I think in order to do that, we would have to get in touch with Rashad Brown and have him file an affidavit saying what he did to Patrick and what has been Patrick been put on the stand.
Yeah, well, 100. Now, so I found him. I know where he is. I have his number. Talk to him. Now, my question is can we get it subpoenaed that he? Based on what he told me.
I mean, is he not willing to do it?
Yeah, but even if he's not willing to do it, I think it can come in through Brady. Brady's Brady.
Yeah. So we would have to file a Brady claim. But we would have to file it under newly discovered evidence.
But how do you receive the testimony of a guy that is refusing to testify?
Right.
But yet you have information that's where I think the phone records are your information to show that none of these numbers were yours.
Right.
So I have a piece of paper in front of me. This is his statement that he provided the courts. Then you put your phone records, then with his phone records, and then you have Rashad Brown's statements that Timothy Patrick kind of shoved in only a clip of it. He suppressed anything else that Rashad Brown said to him.
Right. So he kept that away in order to keep intact their narrative of what they feel like they wanted to present happen to the jury. Because Rashad Brown testified, it changes their whole story, their whole plot. Because I'm no longer the ringleader, and that's how they want to entertain it.
All right. Well, I think we have all the pieces to go for the Brady on Rashad Brown.
Yeah. It's just about actually putting it together, putting the argument together, bring it together, and
I'll help you with that. And then I can put it all raw together, and then it needs to be seen by an attorney and then to pay them to like, here, fucking put the lawyer rest on it. But here's your.
They was telling me to talk to Blaine Jones.
I'll talk to Blaine Jones. I mean, see what sucks is okay. So in Pennsylvania, there's no thing is there a thing called restitution in PA?
Restitution?
Like, you've been wrongfully fucking sitting in prison. You can't even do anything about it. Like Sheldon, for example, when it's all comes out that all the evidence that I put together proves that they fucking lied to wrongfully incarcerate him, can he go and sue PA? No.
Yeah.
You can't.
For wrongful conviction.
Or would you have to sue individually? Could I mean, the officer that, you know.
I mean, I think the best thing to do is go to Blaine Jones, because he is an attorney that likes to be in front of the camera. He likes that publicity and present all this evidence and if he'll take the case.
And he was repping Rachel Del Tondo at the time of her death, so you know that?
Huh?
He was Rachel Del Tondo's attorney at the time of her death.
Who? Blaine Jones?
Yes, sir.
Oh, was he?
Yes, sir. Found that. Oh, wait, here. See, I mean, this is just, were you ever in possession of an identification card belonging to Marquay Jeter?
No.
That is in the police report. That Beaver County Detective Timmy Patrick did travel to Rochester and identified the subject as Davon, and says in a fucking police report that the identification card belonging to that he knows from a previous investigation that Davon is in possession of identification card belonging to Marquay Jeter.
No.
Just lies, motherfucking lies. So then I'm telling you this phone call. Okay, right here. This is the other 911 call we need. Around 2 a.m. or 2 p.m., I went to the emergency services center to pick up a criminal histories, and while picking up the paperwork, 911 dispatchers received a call for Idaho police reporting a burglary in their town, in which a description of a blue Ford Explorer was given. This is like what?
Yeah. That's late as hell. We wasn't even.
I cleared what is this even from? This is from New Brighton. Okay. Yeah. To say that there's around 2 a.m., I went to the emergency services center to pick up criminal histories, and while picking up this paperwork, dispatchers received a call for Alva police reporting a burglary in their town in which a description of a blue Ford Explorer was given. Like, this is not even true.
You have 1 minute left.
Yeah,
All right. Well, are you gonna be around on like Tuesday or Wednesday? Because we can call Blaine Jones if you want.
yeah, we could do that.
Because I think we have the pieces, and I think we have enough now that with the election season coming up, with him talking about Rachel Altondo, this would he'd be, I think, interested in hearing it. And
I think Tuesday would be a good day to do it because we can call them around this time.
okay, all right. Well, then let's do that. I'll talk with Lindsay here tomorrow, and then we'll pick a time.
Goodbye.
Love you, Lindsay. I think we can rope something up here that enough to pitch it to Blaine to show that, hey, what's the best avenue here? Because he's got it all. It's all here.
Okay.
And I mean, his civil rights are just completely. It's insane. Sorry, but it's just so bad. It makes me so angry to look at all this stuff too. Then I just get angry and hangry. But I'll text you here a little bit later, and then we'll pick a time tomorrow to do it all for this week.
Okay.
All right, honey.
All right.
Okay, bye, girl. Oh. So when I'm not live, this is actually stuff that I do. So this is your marathon, where you get to see that, yeah, Oli and I are talking about the Idaho4 case. No, I'm actually talking about people that I know motherfucker didn't do something, because I have 4,000 of their pages that I've went through. I've gone through Davon's whole case. Again, I've never claimed to be a lawyer. I'm not a lawyer, but it's organized and I can tell you everything about it. Davon can tell you everything about it in terms of, like, Lana, you found more shit than, you know. How the hell you aren't arguing in a courtroom some fucking phone records, man, to say that you didn't call my client? Which one of these numbers is his? And then just to, like, I don't know. I would love to be, I think, a prosecutor, because I would just be like, listen, if you want to get people on some fucking him-ho drug shit, then go get them on some drug shit. But I'm not gonna let you trump up some shit to get him, like, just because you believe he's a bad kid or some shit like that. Like, I'm sorry, but if he's such a bad kid, then get him the right way. It pisses me off. A day in the life of Lana. Yes. So back to Idaho4. How are these lawyers in Alpha so inept? Don't know. They're not inept. They just don't give a fuck. You know, don't take on a job that he had. You guys go and get public defenders. Like, they have to do X, Y, and Z. Like, I don't know, why would you come in and be like, here, I'll come and represent you? Like, he doesn't have any money. You know how many motions Ann has put in for Brian? If you take Sheldon's case, this case, Jamie Brown's case, and you put them all together, Ann Taylor still beats all three of those cases by fucking a landslide. I just... And then can you imagine, like, think about before YouTube existed. How does anybody, like, do anything about this? Like, what do you do? I don't fucking know what to do. Let's just get on here and talk about it. I mean, number one question you want to ask an attorney: who is your fucking investigator? I don't give a fuck about you. Who's your investigator? Where are my motions? What's going on here? Like, especially when you hear, well, we don't go to trial. 99% of fucking cases don't go to trial. So why the fuck do I have a litigator then if this shit ain't going to trial? I need a motherfucking numbers shark, a digger. I don't need no pretty suit yet. I'll hit you up when I need to go to trial. You get what I'm saying? Like, I'll go get my suit when I need it. Mm-hmm. I told John that after Aliquippa, I would want a public defender. I mean, I don't understand, like, how you can ethically, like, legit. Davon just told you guys, his lawyer saw him one time before trial. He took the stand. Davon took the stand. He's like, no, I'm taking the stand. I didn't fucking do this. Like, when you want to talk about somebody that's screaming from the rooftop, he's like, I didn't do this shit. My homeboy hits me up, says, hey, will you roll with me? Because I'm 6'3". Hey, will you roll with me? Just make sure that nothing goes wrong. Like, we're just going to go buy some weed. Buy some weed. Turns into a motherfucker is still in prison 20-some years later for, wait, what? Wow. Anyways. Like that, like, and you know what? You'll hear it every fucking time Davon talks. You'll hear him say, listen, I will own my portion of what I did wrong in the situation. This is what I did. This is what I did. No, I did not do that. And no, I did not do this. And he had daughters. And he's like, I am not saying I fucking sexually did anything to anybody. No. Absolutely not. So some people say, like, did he get offered a deal? You know what? Who knows if he did? Who knows if he didn't? At the end of the day, I mean, I was over here basically just gonna say, hey, nobody gives a fuck anymore. Like, I know you want to be a man and you don't want to, but just get out. If there's a way we can get you out, like, and if you had to admit that you did something that you didn't do, you get to leave. Just fucking say that you fucking did it. Go home, be with the people that you love. You deserve that. Because no one's gonna. People don't look at it like, oh man, Davon's such a man. Look at him taking his case like a man. Like, no, they don't give a fuck. There's no one rallying. So tell them what the fuck they want to hear and go home, get your loved ones, and move to Florida. Only because it's warm. I can prove that the liar in Davon's case were the white people. And you know how many times I got accused of being an N-word lover? What the fuck's wrong with you people? What you guys sound so stupid. I didn't realize this was 1960. The fuck? People were writing me that shit. Like, what is wrong with you? No, I'm just a call it as I see it lover. Like, you know, he was in from Atlanta for a funeral. You know, he didn't orchestrate no fucking drug deal, and nor did the phone records prove any of that. In fact, prosecutorial misconduct. Fuck, shit. Did you guys even look at the evidence? How are you bringing forth prosecution in this type of way? There was no gun, there was no bullets, there was no nothing, there's no shell casings, no nothing, and you charge him with a fucking gun charge that you don't fucking have. Explain that to me. Because without the gun charge, he'd be home. Like, anyways, that's why it's so hard for me to bring out the Al Capone books. Because I get fired up. Because I know. Like with the Brian Kober case, like we don't know stuff, okay? I know that people lied to imprison this man, just as they lied about Sheldon Jeter Jr. And how sick is that? Like, there ain't nothing sicker than that. Y'all are fucking wild. You know, you will answer to God one day. Gonna call Lindsay back and ask her what we can DoorDash her for lunch.
Hello?
Hey girl, I want to DoorDash you some lunch.
I'm actually on my way to work.
Well, did you already eat? What do you want? Some dinner instead?
I was gonna say you get cash app me if you want a cash app.
Cash app? I will cash app you, girl.
Alright, I'll send you my cash app.
Oh, I think I already have it. I wanted to buy you a steak dinner or something. Like, I want to do something nice.
Wait, hold on. He's on the line still. Hold on.
He is? I love him. I love him some.
Yeah, I can send you my cash app. You
Oh.
want to.
Oh, are you on? Is Dave on?
Yeah.
I called your woman back to ask her if I could cash app her or send her some. I want to send her a steak dinner. I want to pay it forward. Somebody sent me a cash app, so I want to send it to you, and I wanted to see what you wanted for dinner, or if you needed something, or what.
You can buy me dinner today.
Yeah. Okay. Hey Davon? Is that okay?
Yeah, that's cool.
Is that cool? Are you sure?
Yeah.
Oh, okay. Okay. Where should we order this from, Davon? You could be part of the decision making.
Well, I'm gonna be at work, so I'll have to get something.
Okay.
She's real particular about.
You want some hibachi?
Yeah, I can do hibachi.
Is that you like that? I don't know. Some people like it, some people don't. You know.
I do. I like it strong.
Oh, you do like over there by Is it what?
It's in Robinson.
Oh, in Rob. Is that where you work, girl?
Yeah.
I'm just over here doxing you. No, I'm kidding. All right. Well, then how about this? We agree on hibachi. So I'm gonna go ahead and just text me your Cash App handle, and I'm gonna Cash App you the money, and then you get yourself, courtesy of me and Davon, the best whatever it is that you want to put in your mouth.
Okay, I will.
All right, girl. Love you, Davon. Love you, and I will talk to you guys a little bit later. All right, guys. They say don't get personally invested in people you help. Well, who says that? You know. Let me tell you something. I wouldn't talk about Davon if I thought he was guilty. Just like I wouldn't talk about Sheldon if I thought he was guilty. I wouldn't be like, hey, I think I can get you off on some technicalities. Fuck, no. I don't have time for that. So we are going to Cash App. So those of you guys that have been Cash Apping me today, which I want to give shouts out to, Deja Vu in the house. Thank you for your $10. Catherine, $5. Tiffany, $5. Allison, $5. Kelly, $200. I was like, whoa. Then we have Lindsay became a member. Alicia, thank you so much. Thank you so much. Back to backer. Mike, $5. Sips and tips on sips and tips. Get them, man. I'm gonna try. I hate cheaters. I hate cheater. Oh, yep, there we go. 5-month membership. Vicky, 57, new member group. Yeah. Randy. Oh, good to see you being a member for 5 months. P. Lane, new member. Meg P, new member. Lindsay, new member. Debbie Dow. Yeah, girl. Debbie Dow. I'm going to double down with Debbie Dow. And then William, good afternoon. Good afternoon to you. All right. Oh, wow. What am I doing here? There we go. There has been around 80 gifted memberships today. What? Okay. Oh, love it. Love her, love her, love her. Okay, I think I'm going to send her. Okay. You guys, it's all about love. It's all about like, hey, forgiveness and like, hey, maybe I made a mistake. Maybe this really didn't happen or whatever. Honesty. And because I believe in that, I actually found evidence that I believe would help somebody like Vanessa. Lana, thank you for working. Thank you for thanking me. Let's see. Oh, wait, wrong thing. Okay, here we go. I don't know how to do this. Okay. We sent her $40 for her to get dinner at the hibachi place for Davon's. But she should be able to pick what she wants, right? Hopefully I sent it to the right person. Everybody needs to feel appreciated. Lindsay has worked really, really hard to try to, help me, organizing Davon stuff and stuff like that. And I'm only just one person. And so I've been trying to do stuff for like him, obviously stuff for myself. And there's just a lot going on. And I'm not a lawyer in PA. I wish I could do more. But it pains me when I know that people are attorneys and what the fuck they do. Almost everyone in chat is a member, and it's not a members only chat. Well, whoever was gifting these fucking memberships, man, thank you. Because I want you guys to, oh, good, she got it. You guys, she got it. Now, this song I played. Well, all I know is that song goes out to Bella. It's her favorite song. Take that wig off. Take that makeup off.